Good morning, everybody. Happy Wednesday. Welcome to TCF Live. It's good to have you all with me this morning. Let's start our day in Michigan with Judge Michael McNally, not to be confused with his brother Bob, who we discussed in the pre-show today.
And now here you are, and you're going to ask me for time to pay. See how smart I am? I mean, it's just a replay. How much do you have today?
I don't have anything.
Why not?
Well, really, actually, I forgot about it.
You forgot about it.
So
That's the wrong thing to tell the judge.
well, what happened was.
Did you hear what I said?
Yeah, it is.
That is the wrong thing to tell the judge. I forgot about it. Okay? I don't know how you can forget about it. I want to forget to pay my taxes. You know what I mean?
Yeah, I understand.
I want to forget to pay my mortgage. Where do you work?
I actually do transportation, but I was actually going through a separation with my wife, so I hadn't been out here, and I'm totally slipped.
You make it sound like you live in Brownstown, right?
Yeah, but we're doing a separation, so I kind of stand in rumless these last like.
It's not that far.
Yeah, but I didn't get the memo, so it was like it was a real. It was.
Didn't get the memo.
Just my house that was a little off, so yeah.
How old are you?
I'm 40. But
Time to grow up, don't you think? Tell me when you're going to pay this.
in 4 years, son.
I can give you a payment.
No, I just want the warrant because I got.
I'm not lifting the warrant. No, listen to me. You just want the warrant lifted. Why do you need the warrant lifted? So you come in here and you want me to do you a favor when you've been spitting on us for 11 months and now come in here at 11 months and now come in here and tell me I just want the warrant lifted. Maybe I don't want to lift the warrant. Maybe I want to send you to jail. You think I'm kidding, don't you?
No, I don't think you can.
What do you need the warrant lifted for?
I mean, because I drive.
Well, maybe. Listen. You have ignored us completely for 11 months. I don't want to hear I forgot about it. That's not an issue. You didn't forget about it. I mean, if you forgot about it, then you're even more irresponsible than I think. And that's hard for me to imagine at this point. I want the warrant lifted. I wanted to be president. We don't get everything we want. You come here with no money. Why aren't you working? You said you do some transportation. How much do you make?
I make 18 hours.
How many hours do you work?
Like 7, I'm pretty sure.
70?
7 hours a day is we get a call.
How many days do you work?
4. We got
4?
Friday, Saturday, Sunday.
So you work 28 hours a week. Why aren't you working more? Prime earning years of your life. 28 hours a week, $18 an hour. That's somewhere in the neighborhood of $520 a week gross. You gotta make it. Did you graduate?
Yeah.
Why aren't you working?
I don't know, Barbara. It's just been slow, so I just do transportation. You know.
I wish everybody could do this just for a couple of days and we'll find out how irresponsible society is. You know that?
I can pay it on the first.
The whole thing?
Yeah.
Where are you going to get that kind of money?
I'm gonna get it from my dad. Well, I just wanted to get this cleared up.
I'm gonna let you pay 50 a week and we're gonna start this beginning. And I don't care if you want to get it from your dad, you get it from your dad. Pay 50 per week beginning February the 20th. If you don't have the money, I'm reissuing the warrant. Okay? If you call the court, you say, Judge, I don't have the money, I had a bad week. No problem. But you can't do this. You got to act more responsible than this. So you call the court. If you don't have the money, no problem. Call the court. We'll go on Zoom. I'll give you an extension. Stop ignoring courts. It's a bad habit. Good luck. Knights Lane Holding LLC. You're all set. 25B82558, 25B82632.
The voting. Okay, we're to the vote.
Ma'am, what is your name? Whoa, 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 whoa. You gotta go 10 times as loud as that. Nice and loud.
So that's already.
What is your position with Knights Lane? You're not a lawyer, are you? Or are you?
You.
Listen, so now this has blossomed. Actually, this is Judge Hessen's case, isn't it? I think this is Judge Hessen's, right? Or not? Oh, you got show caused. You show caused the owner. Where you been? Why haven't you shown up?
I was trying to coordinate with the city about this, and I already
We've sent notices out.
the one that I.
Wait a minute. I want you to listen to me. I can't hardly hear you. You haven't shown up in this courthouse on 2 different dates that we gave you. And now we had to show cause you as the owner as to why you shouldn't be held in contempt and be sent to jail. Listen, you need a lawyer. And you need a lawyer fast. You need to hire a lawyer. You can't represent the corporation on a criminal case. Why you been blowing us off? Now keep your voice up. I need to hear you. I can't hardly hear you.
No, I needed to come to court. This was the first time I saw the notice that I needed.
Heather, is this not Judge Hessen's?
Judge, there should be 2 cases for Knights Holding. One is ours that she needs to be. Oh, wait, you know what? Now that I'm looking, I'm sorry. The one that she needs to be arraigned on is showing it falls under her. But let me just double check that date. I also did, while I have you on here, receive a phone call from an attorney at the end of the day yesterday saying that they were going to be retained. They just couldn't make the court date today, but they never filed a
As far as that,
appearance,
they
yeah.
know better than that. We're not adjourning everything. So a lawyer, I'm sorry, if we don't have an appearance, as far as I'm concerned, the lawyer who purportedly was going to represent them is not the lawyer representing them. It's basic. They should have known that the first day they got out of law school.
So Judge, I'm looking in the non-payment one is ours and the one that
I
she has
see.
never been arraigned on is Judge Hessen's.
Here's what I'm doing. I'm rescheduling these. Can you spell your name for me again?
Odessa,
Odessa.
it's the company Odessa, and last name Codilla.
Codilla. All right. I'll just make a note you appeared. We're rescheduling this. You need a lawyer. Reschedule. This is going to go primarily on Judge Hessen. So what are we doing? The 25th?
That would be a crossover on our day. We could do that though.
Well, whatever day.
Or she
do
has
you
them
want-
on March 4th.
What's that?
March 4th, Judge Hessen have Brownstown.
Does anybody have Brownstown next week? The 8th?
She does have it on the 18th, yes.
I'm going to reschedule this to February 18th. We'll do it 9:45. You need a lawyer, okay? We sent the ticket. You got to be careful with this. This ticket was issued back in April of 25.
For some reason, I saw the ticket last month and I was trying to coordinate with the city about how to go about this.
Here's what needs to happen. They think this is what happened, just so you know. They wrote you for failure to register your. When you didn't show up on the civil infraction, it turned into a misdemeanor. So now you have a civil infraction you're in default on, that the company is in default on, that they owe 198 on. And you got, you paid this?
I think that, when I became aware of it, I've been asking the city how I can pay it. And initially we misunderstood because I couldn't find it online. And then
How'd you pay it? Did you pay it through?
when I was able to, I kept trying something because I was finally able to talk to somebody yesterday to get assistance that could guide me in it. And then they told me how to pay, but initially
All right, let's slow down. Did you pay it at the court?
the online payment system.
Do we have,
Not if she paid it within the last couple or the last 24 hours. Prior to that, it has not been paid, Judge.
It went through yesterday, the payment
how long
file.
does that take for us to figure that out when they pay
I
on?
If she used the one system, I can look right now. I'm gonna look. And
Yeah,
see if-
look now, and I got a better idea if she's.
Ma'am, did you pay on the site that charged a fee?
E-courts, e-courts,
I'll tell you what I'm gonna do.
Yeah, that did not go through, Judge. We don't have no payment.
they emailed me the receipt though.
Well, listen, here's what I'm gonna do. I'm gonna let you go down the hall. You see if you can resolve this with her. If she pays this, I'm gonna send it to Brownstown. They might just go ahead and dismiss the misdemeanor. But I need proof. So can you figure that out? Do I need to send the file down, or can you do it with her just going down and showing you her receipt?
She can come down with the receipt. We can look at it.
Go down there and we'll figure something out, but you can't ignore these things, okay? All right, go down and talk to her. We'll see if you paid. If she has, tell me. I'm gonna call in Ms. Foley Carter on this, okay? Thanks. You're gonna go out that exit, see the doors in the back, and then go all the way down the end of the hall, okay? All right, thanks. National Electric LLC, 26B82503. Good morning, council. How are you?
Good morning, Todd Paraford on behalf of National Electric.
So, you registered with the company registered with the township, and they're gonna go ahead and dismiss, right?
That's my understanding. There's a motion to dismiss. We have no objection to that. We have verified. They have registered with the township, and then any issues with a permit or inspection have been handled. So-
Okay. All right, good enough. They moved to dismiss, case dismissed. Good to see you, Mr. Beard. You take care.
Good morning once again, everybody. Welcome to TCF Live. Happy Wednesday. Let's have a good day together today. We'll stay in Michigan. Let's go see what's going on with Judge Middleton.
Operating while intoxicated is a misdemeanor. Get lots of them. Punishable by up to 93 days in jail and a fine of up to $500. Carries 6 points and requires that your license be suspended. My recommendation to you, sir, would be at this point that you plead not guilty and that I get a lawyer appointed to help you. Do you have any objection to that?
No, I don't.
All right. Are you missing work right now?
No, I'm not. I have a temporary driving.
All right. Plead not guilty, appoint an attorney. And set attorney pretrial for 3/6/26 at 8:30. That's the first Friday in March. We're going to be very busy that day. What's your occupation?
I'm a press operator,
Where's that?
American Axle.
All right. So you're not missing work right now?
No, I work second shift.
Very good. So this is going to be in the morning also. It will be the first Friday in March. I'm going to have the court officer take you out to the counter, get the paperwork with your lawyer's name and number on it. You can hire a number or a lawyer of your own if you wish, but I want to make sure that you have one. So then I want you to call the attorney and make an appointment to discuss this case with them prior to March 6th. They'll get the lab report, police reports. This blood draw was on the 16th of January. It should be back by now, but you certainly need to know what that result was before you make any decisions on how to proceed. So you go out to the counter, we'll get a lawyer to help you And I'll see you on March 6th.
Thank you.
Sean Hatfield. Good morning, sir. Are you Sean
Good
Allen
morning. Yes, sir.
Hatfield? This is file number 26131. You got a ticket for no insurance and driving with a invalid license. We get lots of no insurance tickets. They're punishable by up to a year in jail and a fine of up to $500 and not less than $200. Do you have insurance now?
No, sir. We are currently in the process of trying to get insurance. The lowest we got quoted is $500 upfront, but we can't afford that currently.
What about getting your license straightened out?
I'm going up there to the DMV after I get out of my interview today for graphic packaging and scheduling an appointment to get that taken care of.
Very good. If this hits your driving record, it's going to suspend it.
Okay.
And so my suggestion is that we adjourn this and give you some time to get that stuff straightened out.
Okay.
Adjourn it about a month. Is that acceptable?
Yeah.
All right, well, you were supposed to show up on the 4th. Today's the 11th, so you didn't have any luck with either of those things in the last week?
No, we were out and about trying to get that taken care of and whatnot. And insurance was the first thing on my mind to get so the vehicle was legal and whatnot. I didn't think about going to set up the appointment.
All right, well, let's set this out. Today is February 11th. Let's set it for further complicate things. Part of this is ordinance and part of it is state statute. So I'll put it on a Wednesday. Continue to March 25th. Are you missing work right now?
No, sir. I am currently between jobs.
All right, well, there's a lesser charge of each of these. If you come in with a valid license and insurance, the prosecutor will be very likely to give you some consideration or reduce these charges.
Okay.
Wednesday, March 25th at 8:30. Courtroom C, court office, pretrial conference, bring license and insurance. So we'll take another crack at this a little more than a month from now. See how you're able to do.
All right. Would you like to?
Yeah.
Okay.
All right, you're good to go. Vivian, I got one more non-translator case and then we'll, I think another one of our defendants may have shown up a little late.
Okay.
Maddie Witt. Good morning.
Morning.
All right, this is file number 252482. People versus Maddie Veronica Witt. That's you?
Yes.
I used to know you as Matthew Barber.
Yes.
All right, way
I
back,
legally had it changed and I've had a full sex change. So,
all right, but yeah, back when I was prosecutor, we had met years ago.
yes,
All right.
known you for a long time.
Well, good morning.
Morning.
I'll address you as Maddie Witt. You got charged with having no insurance. Do you have insurance now?
It's a funny story because that night it was bad weather and I was pulling over on the side of the road. I thought my tires were slipping, but it appeared not to be that. It was a bad transmission. I had to have the van trailered home that miserable night, and I have not fixed it, so I have not done insurance. I don't have a vehicle.
Do you plan on reusing this or getting rid of it?
The van,
Yeah.
getting rid of it.
All right, we'll have a seat for a minute. We'll see if we can get the prosecutor to talk with you.
Okay, because I am a bus rider this morning.
Do you
My
need
bus is due
tickets?
back at 9:18.
All right, good to know that. Do you need a bus ticket back?
No, it's already paid.
All right. All right, have a seat. They're supposed to start the pre-trials at 8:30. The persistent that usually does them is off for a little bit. So we'll get somebody, but you got a bus to catch at 9:18. We'll let them know that. All right. January 11. What kind of van was it?
It was a Mercury Monterey. Was actually I hate to get rid of it, but it was a rare one.
All right. That's a state statute.
2005.
All right, Laura, would you let the prosecutor know we need assistance with a pretrial? And he's got to catch a bus. Or she's got to catch a bus. All right. Senor Nico Chacon Villa Somil, would you come forward, please? Buenos dias.
Buenos días. Good morning.
The lady on the screen is here to help us interpret because I don't have any Spanish.
La señora en pantalla está aquí para ayudarnos a interpretar porque no tengo español.
And I want to make sure that you understand everything.
Para asegurar que se le entiende todo.
I can't hear, Your Honor. It's just very low.
Yeah, we can't hear you very well, Vivian.
I'll try to speak up, make sure my volume is up. Is that better?
Yes. Ms. Montero, would you raise your right hand? You swear or affirm to the best of your ability you will interpret these matters from Spanish into English and English into Spanish.
I do.
Would you state your name for the record, please?
Vivian Montero, Court Interpreter 18369.
Senor Chacon Villanosmi, Villosmil, you got a ticket on January 24th of 26.
Señor Chacón, Dios mío, usted recibió una multa el 24 de enero de 2026
For driving without a valid operator's license
por conducir y no tener una licencia vigente
and a civil infraction of defective equipment.
y una infracción civil por tener un equipo defectuoso.
The first charge is a misdemeanor.
El primer cargo es delito menor.
It's punishable by up to 90 days in jail.
Conlleva una máxima penalidad posible hasta 90 días de cárcel.
and a fine of up to $500.
Una multa hasta $500.
The second charge is what's called a civil infraction.
El segundo cargo es lo que se llama una infracción civil.
It is punishable by a fine only.
La penalidad es una multa solamente.
The normal fine for that is $105.
La multa normal para ese cargo son $105.
This gentleman in the corner over here is the city attorney or assistant city attorney for Sturgis.
Señor que está aquí en ese rincón es el Ministerio Público para la ciudad de Sturgis.
His name is Mr. Tim George.
Su nombre es licenciado Tim George.
Mr. George, would you dismiss the civil infraction if he pleads to the other charge?
Licenciado George, ¿usted estaría dispuesto a desestimar la infracción civil si él contesta culpable en el otro cargo?
Yes, Your Honor.
Sí, su señoría.
The city attorney would dismiss the defective equipment ticket, which would save you $105.
El agente del Ministerio Público está dispuesto a desestimar la multa de infracción civil, lo cual le ahorraría $105.
If you plead to the no operator's license charge,
Si contesta culpable al cargo de no licencia,
it will give you a fine and I'll give you time to pay it if you need it.
voy a poner una multa y le doy tiempo para pagarla si necesita tiempo.
According to this ticket, you were driving a car in Sturgis at 9:30 at night on January 24th, and you did not have a valid license.
Según la multa, usted estaba conduciendo un auto en la ciudad de Sturgis a las 9:30 de la noche y usted no tenía una licencia vigente.
They stopped you for driving without a headlight.
Le pararon porque uno de los focos en la parte delante del vehículo estaba quemado.
According to your driving record, you don't have any driving record because you don't have a license.
Según su historial de conducir, pues es inexistente porque usted no tiene licencia para poder conducir.
Are you willing to plead to that charge of operating a vehicle without a license?
¿Está dispuesto a contestar culpable ese cargo de conducir un vehículo sin tener una licencia?
Sí.
Yes.
Did anyone threaten you to get you to plead to that charge?
¿Alguien le amenazó para que contestara culpable?
No,
Or promise you anything?
¿O le prometieron algo?
no.
Do we have an advice of rights?
Que si tenemos la notificación de derechos en español.
Do you understand that by entering this plea, you're giving up these rights that we gave to you in Spanish?
Usted entiende, al contestar culpable, está renunciando todos los derechos que están en la hoja en español.
Where were you going that night?
¿A dónde iba aquella noche?
Lo que pasa es que yo tengo, mi esposa está embarazada y como ha tenido muchos dolores de panza, íbamos a buscar unas medicinas urgentes y como no teníamos quien nos llevara, me puse nervioso porque era un dolor fuerte y agarré simplemente el carro y...
You have to speak in short sentences.
Okay, sorry.
My wife was pregnant at the time and she was having belly pains. So we went urgently to get some medication. There was no one to take us, so I took the vehicle because I was very nervous regarding what was happening.
All right, and you did not have a license?
Y usted no tenía licencia.
No,
Did you ever have a license anywhere else?
¿Había tenido una licencia en su país o en alguna otra parte?
sí,
From where?
¿De dónde?
en Venezuela.
From Venezuela.
All right, but it's not valid presently?
¿Pero está vigente actualmente o no?
Como tengo mucho tiempo sin estar en Venezuela, no sé si estará vigente todavía.
Since I haven't been in Venezuela for a long time, I don't know if it's still valid or not.
It's not.
No lo es.
I don't believe this will have any residency status issues because it's a very minor misdemeanor, but it is a misdemeanor. Do you understand?
No creo que le vaya a afectar su situación migratoria porque es delito menor, pero sigue siendo delito menor. ¿Entiende usted eso?
Sí,
Yes.
All right, the fine is $100.
Multa 100.
There's $125 of costs that go to the state. Thank you, Angelique.
$125 este costo estatal.
disculpe, ¿cómo? No,
There's a
sorry.
fine of $100 plus $125. This defendant got a ticket for no insurance, but the vehicle is gonna be scrapped.
Okay,
And they're not gonna drive it anymore, and they had to get it towed.
okay,
All right.
thank you.
Multa
Um,
100, costo 125.
Disculpa, por decir una cosa.
May I say something?
Yes,
Yo puedo mandar una licencia vigente de mi país para acá para yo poder manejar.
Can I try to renew my license in Venezuela and have a family member or someone send it to me here so that I can drive here?
no.
You know,
Once you live here, you have to get a license here.
cuando uno está viviendo aquí por mucho tiempo, tiene que sacar la licencia de acá.
And right now, things are not good in Venezuela.
Y en este momento las cosas no andan bien en Venezuela.
I'm always amazed by our Venezuelan residents.
Siempre me quedo asombrado en cuanto a los residentes aquí de Venezuela
That they managed to get here at all.
que pueden lograr llegar acá.
Did you go through the Darien Gap?
Usted tuvo que pasar por de la jungla Darien.
Yeah.
Yeah.
Muy difícil, muy difícil.
Very difficult, very difficult.
Very dangerous.
Sumamente peligroso.
Sí, duré como 6, 7 días para pasar.
Yeah, it took us 6 or 7 days to get through.
Oh, boy. So you don't want to go back to Venezuela, but you need to pay this fine of $225.
De hecho, es que usted no quiere regresar a Venezuela, pero tiene que pagar la multa de $225.
Can you pay that today or do you need time to pay it?
¿Puede pagar ese monto hoy o necesito tiempo para pagarlo?
Disculpe, ¿cuánto sería?
How much would it be again?
$225.
$225.
225. Sí, yo creo que lo puedo pagar hoy.
I think I can pay it today.
Okay. I have this problem almost every day.
Tengo este problema casi todos los días.
I can't fix it. I wish I could.
No puedo cambiarlo. Ojalá que si pudiera.
But in Michigan,
Pero en el estado de Michigan
it's almost impossible to get a valid driver's license unless you have lawful residency status.
conseguir una licencia licencia a menos que uno ha regularizado su situación migratoria aquí.
The court officer will take you out to the counter. You can pay the fine, and then you're free to go on about your business. Thank you, sir.
Acompaña el asistente del sheriff a la oficina para pagar la multa y ya se puede retirar. Gracias, señor.
Okay, thank you, señor.
Morning once again, everybody. Happy Wednesday. It's TCF Live. It's good to have you all here. So we're going to do something different. We're going to go to Lake County, but it's not going to be Judge Collada. It's going to be Judge O. Got it paused for a minute because if you can, zoom in on the windows on the left side. And this is bizarre. I'm not exactly sure what we're seeing. So it looks like this courtroom is on an upper floor, like maybe a fifth or sixth floor, and we're looking down on the city, right? But then if you look in the bottom left, that window pane, it looks like there's a car sitting there. Because you can kind of make out the wheel and the front grille of what maybe looks like a truck or an SUV. But that doesn't make sense if this courtroom is sitting up, because again, from the perspective, it looks like it's looking down on the city. So I can confirm that Judge O'Donnell is real. I can confirm this is not AI slop. But tell me that isn't bizarre what we're seeing in the windows. And what we're seeing in the window panes don't necessarily match either. If you look on the right side, it doesn't look like it's a progression upward. So it almost makes me wonder if those windows aren't real and what we're seeing is like graphics that were put in there or something to like seal those windows from people looking in. I have no idea, but it's just absolutely bizarre. So I wanted to point that out. I'd never noticed it before when I looked at his courtroom, but as I had it paused, I was looking like, this is totally weird. And Barbara, by the way, thank you for the $5. You say, please keep Wahoo in your prayers. And Great Granny, thank you for $2. You say the same thing. And yes, absolutely. For those of you who don't know, Wahoo, a regular here, his sister passed away a couple days ago. And he wanted to let all of you know that the reason he is absent is because he is dealing with that, and he hopes to be back soon. Anyways, let's unpause this and let's spend some time with Judge O'Donnell.
All right, Ms. Smith.
Thank you, Your Honor. On behalf of Ms. Hudson is respectfully asking the court to impose a period of community control in this matter. Ms. Hudson has accepted responsibility for her conduct through her guilty plea. She's 41 years old, married, and has 4 kids. 3 of those 4 kids are currently residing with their father. Temporary emergency custody was granted as a result of this case. However, Ms. Hudson does have a juvenile court hearing set for early March to address that, the custody situation once this matter has been disposed of.
Where, over here?
Yes, that's correct. Your Honor, Ms. Hudson previously suffered from a heroin addiction. It's something that she's been able to maintain sobriety from for 4.5 years. And as the court's aware, she has previously been charged with child endangering. 2 of those prior charges were a result of her heroin use, which is something that she has conquered and been able to keep at bay. However, as the court's aware, she does still struggle with periodic use of other substances. Upon her bond being reinstated in this matter, Your Honor, Ms. Hudson did obtain an alcohol and other drugs assessment through Sparrow Health. She indicated that she has continued to go to Sparrow Health weekly for drug screens and counseling. And if this court were to order that she complete intensive outpatient treatment, they do have that available as well. Ms. Hudson has 59 days of jail time credit in this matter, which gave her a significant amount of time to think about her conduct and how she ended up in this situation, as well as ways to avoid it happening again in the future. And Your Honor, Ms. Hudson is respectfully asking the court to grant community control without additional jail time so that she can tend to the parenting and custody matters.
All right. Ms. Hudson, what do you have to say?
This was a big eye-opening mistake. I've been sober from heroin for 4.5 years, and I guess I became a little complacent with that. So it was probably a good thing that I came in here testing positive, because I don't want there to be any way that I ever risk actually permanently losing my kids, because I care about them a lot, and I do try to put them first. I try to put them first all the time.
It seems like you spent time putting your drug use first.
I did. You're right about that. And this has been very eye-opening, sitting in jail for 57 or 59 days, whatever it was, and having no control over anything. The fact that they were able to go to their dad that never really saw them anyways before that, it really hit hard. And I don't want there to be any way that I permanently lose them, because I care about them a lot. I feel like I'm one of the only people that does.
So where are they now?
They are with him, but technically with his mother in Chardon at the moment. She's elderly, she can't control them. My one daughter is refusing to go to school weekly, and she can't do anything about it because she's in her 70s and she's not well.
Where is their father?
He is working or never around. I don't know what he does, but he's never there.
Okay. How old are they?
My oldest, who is 15, is actually still with me because she refused to go there. She did not want to go with him. And then the other three are 13, 11, and 6.
Okay. And before all this happened, last, July?
Yes, that's correct.
That's when the younger three went with him, right?
No, he only took emergency custody of the one, the one that this whole thing involved. And then the other two, he did not take custody of until like 3 weeks after I was in jail.
Okay. So what had been his contact with them prior to this?
He is very in and out. He's not consistent. His parents live half the year in Florida, and they will come back periodically when they're living down there, and he will see them when his parents are around, and he disappears as soon as they go back down to Florida. I think.
How long has he been doing that?
Since we have not been together in 2020.
Okay. So those three don't want to be where they are?
They do not. And he doesn't even really seem to want them, because we've kind of discussed the custody. Once we saw the magistrate over at juvenile courts, and she said if we can come to an agreement with custody, that she would sign off on it. And he's okay with seeing them once a month, which I doubt he'll do, but that's what we'll have in paper.
He's okay with what?
He's okay with only seeing them once a month, like one weekend a month. And then I take them the rest of the time. But I doubt that'll last very long, but it's what will be on paper through the courts.
Well, that's your hope or expectation in March?
Yeah.
March what?
You know, I want to say it's the 11th. I don't know. I was going to actually go over there because I got to pick up some paperwork so that we can work out a schedule.
How come you don't know that date?
We were just there, and I don't know, I didn't have the paperwork in front of me.
Okay, their misery is because of your actions.
Yes.
Not because of his actions.
No, oh, I know, I'm aware of that, I know. But I went there like a couple weeks ago, and I wasn't going to miss that, so.
Do you have a drug problem right now?
Right now, no. No.
When did the drug problem stop?
I guess when you put me in jail.
Why were you using cocaine while this case was going on?
We were in the middle of moving, and I have a hard time with motivation when it comes to big things, and like things that are just seem like too much. I get overwhelmed very easily, and I don't know. It's not an excuse, but I just thought that maybe that would help. I don't know.
Well, you say you quit heroin, what, 4.5 years ago?
Yes, that's correct.
Okay. Why did you quit heroin?
Because I was put in jail.
What?
Because I was put in jail and I didn't want to lose my kids.
Okay, and those were the child endangering charges were directly related to that?
Yes.
The previous ones?
Yes.
How did you stop using heroin?
I experienced a long time of sobriety, and I realized that I did not want to live like that anymore. The day-to-day struggles, trying to obtain heroin and get money for it, and I didn't want to live like that anymore.
So when did you start in on the cocaine?
It was probably in September when we moved. It was end of August, beginning of September. And it wasn't.
25?
What's that?
Of 25?
Yeah.
Okay.
And it wasn't a very consistent use. I don't know why I thought it helped me,
What led to your decision? And I'm going to assume for the purposes of this conversation that you're being honest with me.
Yes.
Okay. Which drug addicts usually are dishonest.
I understand
and
that, yes.
manipulative, right?
Yeah.
So assuming that you're being honest with me, why did you, after 4 years of not using drugs, what led to the decision to take the cocaine the first time?
Because I was hanging out with somebody that had it.
Who?
What's that?
Who?
A friend of mine that works at a bar in Wickliffe.
Which bar?
It was Kate's Bar.
Ah,
Yeah,
Kate's
sure.
Bar.
Yeah.
It always comes back to Kate's Bar and Giovanni's. Okay. Who is that? Who is your friend?
My friend Brandy.
Brandy?
Yes.
Bartender at Kate's Bar?
Yes.
Okay. Why were you hanging around Brandy at Kate's Bar?
Because I hadn't seen her in a really long time. And she texted me one day and we hung out and that was it.
Okay. Were you drinking at the bar?
A little bit, yes.
All right. What made you think that was a good idea since you're a drug addict?
Because I've drank occasionally and I've been okay with that. I mean, up until making that decision, I can have a few beers and be fine and not need anything the next day, but after doing that, it probably is a different reason why I can't drink. Not necessarily that I'll become addicted to drinking, but it does lead to bad decisions for sure.
Okay. So that was in September?
Yes.
And then when's the next time you used it?
I don't know, but the last time I used it was the weekend before I came here for court.
Okay. Well, how many times did you use it in between September and the last time you were here?
Between September and the last time I was here, it was probably maybe 5 times. It wasn't many times.
Did you realize in September when you did it the first time, did you realize that was a really stupid and horrible decision?
At that moment, no, I did not.
Why not?
Because I felt like I said, we were in the middle of moving, and I just felt like it helped me, and I don't know, but...
How did it help you when you were moving?
It gave me a little more energy.
I know, but you were sitting in a bar using it.
Well, that's when the idea came about to use for moving. Because
So
I
did you
used
use
that
it
night at the
that day
bar.
you were at the bar?
What's that?
Did you use it the day you were at the bar?
Yes, I did.
So Brittany's dealing drugs out of the bar?
What's that?
Brittany's dealing drugs out of the bar?
No, but she just had some.
All right. Where did you get it the other 5 times?
There is a guy in Cleveland off of Wayside. I don't know his actual name. I think he goes by Ace.
Ace. That's not Ace from Detroit, is it?
Oh, I don't know. I don't know. I mean, these guys don't give you much information
How
about
did you
them
manage to find Ace?
from a long time ago.
Well, where's Wayside?
It's off of Euclid.
Where?
Off of Euclid Avenue.
Off of Euclid. Where? Around where?
Right into Cleveland, like right when you get into Cleveland. It's a couple streets down.
So how long had it been since you bought anything from Ace?
A long time, years.
Which was what? Heroin?
Yeah.
So how is it that 4 or 5 years later, you were able to contact Ace?
Because I still had that number in my head.
In your head?
Yep. I dialed it every day for years.
So Ace kind of fanned out in cocaine with heroin?
They usually have everything.
Why did you keep going back?
For the cocaine?
Yeah.
I mean, it was a few times, I don't know, because I would have big projects like moving a U-Haul storage unit or moving, it wasn't very many times, it was a few times. It was usually when I came back up here for something.
Well, we're talking about you test positive. In November, right?
That's correct.
Okay, so between sometime in September and November, so a period of 2 months, you used at least 6 times, right?
Probably, yeah.
6, 7 times, at least 7 times. So it's more than once a month that you indicated to the evaluator, right?
No, I wouldn't say that. Well, yeah, I guess because it was in between such a
It's
short
7
period of time,
times
maybe.
in 2 months, at a minimum, 7 times in 2 months, right?
Probably a handful of times, yeah, could be.
I'm just going on based on what you're telling me. You told me initially November and then 5 other times.
Well, I mean, initially it was September, and then,
Right.
yeah, probably 6 times.
Okay. So the last time you used was in November?
Yes, that's correct.
Why haven't you used since then?
Because I want to prove that I can do this for myself and for my kids and to the court, that I can be out and maintain sobriety, because I want this. I don't want to live like that anymore. I don't want to go down that path again. I really don't.
I would imagine you don't.
Because it's hell. It's literal hell.
Doesn't seem like a good time.
It's not.
So this move down to Marietta has caused you some anxiety to the point you feel overwhelmed with things, right?
I do suffer from ADHD, and I was refusing to take any Adderall or anything like that for a really long time, and I don't want to.
That's a focus issue, isn't it?
Yes, it is.
Okay,
And
so this overwhelming issue, do you have some sort of mental health diagnosis that
I have
causes
been
you to
diagnosed with
become-
ADHD, which, yes, it presents as, for a lot of people, that you get overwhelmed by big tasks, and it's hard to start, and procrastination and things like that.
When were you diagnosed with that?
I think it was 2019. It was when I was at Laurelwood. The psychiatrist that I talked to there diagnosed me with ADHD.
All right. And you were at Laurelwood for the heroin stuff,
Yes,
right?
that's correct.
Okay, so were you prescribed medication at that point?
She prescribed me Adderall for a short period of time while I was doing IOP there and then aftercare. And then after she was unable to prescribe me that, and I was.
Why?
Because she was no longer my doctor.
Okay,
If
then-
I wasn't doing IOP or aftercare there, I couldn't.
Okay, so did you go to another doctor then?
It was hard to, no, actually I didn't. I relapsed. And it's hard to find somebody else that might, and I don't necessarily even want to be prescribed Adderall, to be totally honest. But I have not done much therapy when it comes to that issue.
Why not?
I don't know.
Well, you didn't want to, right?
Maybe. I mean, it's not that I didn't necessarily want to. I had a lot on my plate at the time. I have a daughter that has major behavioral and mental illness issues, and a lot of my time has been spent dealing with her.
How do you deal with her?
I've had to take her to therapy.
What are you trying to accomplish?
With her,
Yeah.
I just want her to be happy, and she just never seemed happy.
So you think it's important to pursue evaluation treatment for you?
I just don't put myself first.
Okay, now part of her unhappiness is probably
It probably
because of
is
this
my
shit
fault.
going on, right?
I know. I'm aware.
Okay.
Yeah.
So until you cure that, you're not making yourself happy, you're not making anybody else happy in your life.
I've been working on that. I have.
What is this Spiro place you went to?
They do drug and alcohol treatment. I've been going there once a week. They do have IOP.
They concluded you don't need any further treatment?
That's what they said, and I told them, but I've been going there every week, because the first woman I talked to said, she said she'd set up a drug and alcohol screen and an appointment with their doctor there, and she said that would probably be it, because she didn't feel that I had a problem.
Well, did she feel that you didn't have a problem based on what you were telling her?
Yes, that's correct.
So you weren't being truthful with her?
No, I was being truthful with her. I told her it was a couple times.
I don't know how you could, so did you tell her what you told me?
Yes, and I was, to be totally honest, I was surprised, and I have talked to the doctors since then, and I've asked them about IOP. They said that they have it, so I can attend IOP.
How could they conclude that? They don't seem, if that's all accurate, they don't seem like they're very, very good at what they do. Not that that matters, because they could be the best at what they do, and if you don't put any effort into it, it doesn't gonna matter.
No,
So. So when's the last time you had a mental health evaluation?
probably, I mean, I don't know if they would have considered that a mental health evaluation when I went there. I'm not really sure. They asked me a bunch of questions, but I mean, before that, it's been a while.
When are you, how long are you gonna be living in Marietta?
That's gonna be my permanent residence.
Are you working right now?
I actually, I just had a job interview with a company for sales. and it's a remote position, and I'm supposed to hear back from them sometime today. And she already told me that I'd probably, if they do hire me, I would start training on Monday.
What kind of, where, what kind of company?
It's called the Weed Man. It's like a lawn thing, and it would just be remote. They're a company that does yard work, or not yard work, but kind of like fertilizing and weed control, and they do that across the country.
You strike me as somebody who's come here, and the goal, once you got here, is to get out of here with as little disruption in your life as possible. I sense that through your evaluation and your statements. If that's your goal, you may temporarily accomplish that goal, but in the long run, you're going to fail, because I'm not sure you're interested in addressing your situation the way it needs to be addressed.
I want to do whatever I need to do to avoid any sort of legal issues. I want to be able to take care of my kids. I want to do...
So whatever, when you say whatever you need to do, what exactly is that?
Any treatment that I need to do. I mean, I'm willing to do IOP. I know that I can do this. I've been sober from heroin for 4.5 years, it was hard, very hard in the beginning.
You know, when you bought that, or when you got that cocaine from Brittany, and when you bought it from Ace, did you get some sort of written guarantee about what you were getting?
No.
Then how did you know what you were getting?
I didn't.
How did you know there wasn't heroin in it?
I didn't know that.
How did you know there wasn't fentanyl in it?
I did not know that.
Okay. But you did it anyway.
I guess it never really crossed my mind, but yeah, I did it.
See, to me, somebody that was hooked on heroin for a long time, which meant fentanyl, essentially.
Yeah.
Would after they stop using it for 4.5 years, that would be the first thing that crosses their mind. But that was a situation of you putting yourself before anybody else, namely your kids.
You're right.
And you doing what exactly you wanted to do, consequences be damned. That's what concerns me about you. Now, could be I'm reading you wrong, I don't know.
I think you are. I mean, because I know I can do this.
Well, time will tell. Because in the long run, it doesn't matter if I'm reading you right or wrong. Okay, you're going to do what you're going to do. And it's going to be either right or it's going to be wrong. So, anything else you want to say?
At this time, no.
Simile?
Thank you, Your Honor. It's clear that the defendant hasn't taken responsibility in this case. She's not been honest, she's not been accountable. She's minimized her behavior, both with her drug use and what happened in this case. She said that she was on autopilot and this was an honest mistake, but she left her 10-year-old daughter in a public place late at night. It wasn't a brief oversight. This was a serious lapse in parental judgment that left her daughter at risk. Her daughter was crying hysterically, scared. She came out of that restaurant. Her mom was gone. And the defendant's story lacked any credibility. She said, I was on autopilot, I just picked up this order, I delivered it, and I went home. But the flock cameras paint a different picture. She was at Maple Grove and State Route 91 in Willoughby at 10:41. At 10:45 p.m., Willoughby Police Department is dispatched. At 10:54, she's at the Willoughby Hills Towers, presumably making her delivery. And again, at 10:59, she's back at Maple Grove Road and State Route 91. There's no flock hits for 37 minutes, and then she shows up in Menor. And she doesn't call the Willoughby police until 11:58 p.m., over an hour after she's left her child. And this isn't the first time that she's endangered her children, as the court is aware. She says she's going to do anything for her kids, but her behavior, her repeated behavior, suggests otherwise. She continues to use drugs, and she continues to endanger her children. She said that she had a drug and alcohol assessment, and they didn't think she needed any treatment. Again, minimizing her drug use and her behavior. Her prior convictions have represented multiple opportunities for intervention and for her to change her behavior, and she still hasn't done it. 2019, she overdosed in front of her kids. 2020, she left her 4 children in the car for over an hour while she was inside BioLife. 2021, again, she overdosed in front of her kids, and the police found syringes that were readily accessible to her children. And in 2023, a neighbor found her 3-year-old son walking in the middle of the road, a half-mile away from her home, with a diaper so full it was hanging off of him and hanging on the ground. And then again, 2025, she leaves her daughter. She somehow escaped any real accountability for any of these charges. They were all pled down to either misdemeanor child endangering or a criminal trespass charge. And she continues to do these things to her children. So the state is asking the court to impose a sentence in this case that sends a message to the defendant. Enough is enough. Her kids deserve better. For that reason, the state is asking the court impose community control sanctions with significant jail time. Thank you.
All right. Why don't you have a license?
I just haven't had the money to do everything I need to do to get it back.
What do you need to do to get it back?
Well, at this point, since they changed some law, I can now go and pay my fine through the BMV, and I got to take a driver's test and also get an SR22.
Okay. When are you going to do that?
As soon as I can.
Okay. What were you doing hanging around 91 in Maple Grove?
I was doing DoorDash deliveries.
Okay. Well, if there's these flock cameras all over the place, why did it not register anything for 37 minutes when you were in that area?
I don't know.
Were you hanging around the Skylight Inn maybe?
No, absolutely not.
Why not?
Because I've never been there before and I don't know anybody there.
You know what that place is?
I do, actually. Yeah.
How do you know that?
Just from, I knew a guy that I used to work with. He divorced his wife and he was living there for a while. I've never been there though.
Well, it's a big drug den is what it is.
Oh.
Makes me think maybe you were hanging around the Skylight Inn.
I was not. I was doing deliveries.
Okay. Because it didn't register with you that your 10-year-old was no longer in the car for quite a period of time.
I was doing DoorDash deliveries.
I know you were.
Yeah.
I know you were.
I was not at the Skylight Inn.
All right, I reviewed the pre-sentence report and the evaluation, and I have considered all the provisions in 29, 29, 11, 12, and 13. I've listened to Ms. Hudson and counsel. And having considered all the provisions of the applicable statutes in this case, I'm going to place you on community control for a period of 4 years. You're going to serve 89 days in the jail with credit for 59. You have no drugs or alcohol and you'll be screened. You're going to complete an intensive outpatient drug and alcohol program and follow recommendations. You're going to obtain a mental health evaluation and follow all recommendations. You're to see only one doctor and one dentist and one pharmacy for prescription medication. Any medication that is prescribed, you're to take only as prescribed. You're going to sign releases so probation can get your records. You're going to attend at least 2 AA or NA meetings per week and obtain a sponsor. Going to obtain full employment, get a valid driver's license, and pay the cost and supervision fees in this case. Do you understand the terms?
Yes.
Mr. Tompkins, any other terms you think are applicable?
I don't believe so, Your Honor. Just with the probation, is it going to stay here or do we transfer?
And I'm getting there. Any question about the terms?
So am I doing more jail time then?
Yeah.
No.
All right, if you violate the terms, the state will file a motion to terminate your community control, and if I find you violated, then you face potentially 18 months in prison. Do you understand that?
Yes.
Do you live in the city of Marietta?
Yes.
What county is that?
Washington.
All right, we're going to transfer this to supervision of Washington County. But I want to make sure, Mr. Tompkins, that we're keeping tabs on this rather than just some half-assed monthly report or whatever they do. So I want to know if she's actually doing what needs to be done so that she keeps coming in and out of court. Anything further, Ms. Himmeline?
No, Your Honor.
Ms. Smith?
This time, Your Honor.
So I will say this for Judge O'Donnell. He gets a good amount of swear words on the record. I'm going to go back, and I'm just going to freeze it, because before we went in here, we were questioning what we were seeing through the windows. Because if you look at it, it looks like it's looking down upon a city. However, thanks to Austin, who sent me a photo of the courthouse, I understand what we're seeing now. We're either looking out the window from the first or second floor. I believe, given the angle, it's the second floor. But we're in the courthouse, and next to the courthouse is a church. So what we're seeing in that bottom left pane there is actually a vehicle. But behind that, in those middle panes where it looks like they might be like buildings, that's fencing. Those are stone posts, and if you look between them, there are metal slats. And then what's behind that fence, and you see like the stained glass window from it in the top there, that is a church. So that is what we're seeing, ladies and gentlemen, in particular courtroom window. It all makes sense now. Thank you, Austin, for your detective work and helping us figure that out. Okie dokie. Michigan, Judge Simpson.
You may be seated. And I don't think we have anybody from the prosecutor's office today. Need a waiver. Easter, Brown, and Garen. All in like a law firm there. That would be scary. I don't really think the order matters. Court, let's call the case, people, versus Sean Bauer.
Good morning, Your Honor. Dan Garrett on behalf of Sean Bauer. Sean, state your name.
Sean Bauer. Thank you, sir.
Your Honor, of course, Mr. Bauer is here for sentencing. We've reviewed all the reports. There are no factual corrections. Recommendation looks appropriate. I'm asking Your Honor to follow it. He's worked very hard on his sobriety. He's very proud of that. I believe this reflects that. He can pay all his fines and costs this morning.
All right. Sir, is there anything you'd like to tell the court before I do impose sentence?
No, Your Honor.
The court acknowledges this is not a serious misdemeanor as defined by statute, however, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of individual counseling, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. Therefore, the sentence of the court will place you on probation for a period of 18 months. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $540 probation oversight fees. You can pay that today, sir.
Or you'd like to pay all the fines and costs. You want to do the probation oversight fees later?
Yeah, I don't have the probation fees.
So you can pay the fines and costs today.
Exactly.
Yes.
And then when can you pay the probation oversight fees?
You have a time frame in which you can pay those?
28 days when I get my next.
Where the? Nobody says to me 28 days. Unless you're thinking
I'll
football.
have to calculate.
Is it? No, it's okay. So you need a month.
It was March 11th is when I get my next severance.
He was actually calculating days.
Yeah, it's good for you.
No, I like it. He was gonna do 28 days. He knew February only had so many days. And he's right. That's how many days it is. Paid by March 31st, 2026. Will that work for you, sir?
Sure.
All right, thank you. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. Attend individual counseling with status reports to probation. Attend 2 AA meetings per week with monthly verification to probation. Provide proof of victims' impact panel attendance to probation. Continue to scram tether for an additional 30 days, in lieu of 4 days in jail. I'll order 93 days in jail. Credit 1, the balance is suspended. All right, thank you, sir.
Thank you.
Good luck to you. Court calls case People versus Michael DeWitt.
Morning again, Your Honor. Dan Garrett on behalf of Michael DeWitt stepping forward. Michael?
Michael DeWitt.
Thank you.
Your Honor, we're here for sentencing. I understand there may be a victim statement today.
All right, very good. What does he have a seat there?
Your Honor, the victim in this case is Joshua Wade.
All right.
Hello, Your Honor. My name is Joshua Wade. I'm the victim in the case. Your Honor, I provide the court a written statement, but I wanted to provide a brief verbal statement in summary. It is my understanding that Mr. DeWitt has shown true remorse over this incident and is prepared to make full restitution. I'm also under the understanding that he has no prior criminal record. I support the terms of the plea agreement as I understand them, namely a period of probation, anger management, and with a delayed and restitution with a delayed sentence so that he does not end up with a permanent criminal record. Mr. DeWitt's actions impacted me in several ways that I mentioned in my written statement. However, I want to call attention to the impact on both myself and Mr. DeWitt that did not occur, but could easily have. In Michigan, more than 1 in 10 adults holds a concealed pistol license. We are ordinary citizens who go about our daily business much the same as everyone. We don't look any different, and yet we carry with us the means to effectively defend ourselves from grave danger. On the day of Mr. DeWitt's crime, I was carrying a SIG P226 9mm with 15 rounds and 1 in the chamber. As he approached my vehicle and confronted me, my primary thought was to ignore his provocations so that I would not be placed in a situation where I may need to defend myself with force. When I parked and Mr. DeWitt remained in the area, I went inside rather than risk a physical altercation that could have had tragic results. As you know, Your Honor, Michigan has no duty to retreat. However, I chose to retreat from the area while Mr. DeWitt maliciously damaged my vehicle rather than remain and potentially become involved in a situation that could have been tragic for Mr. DeWitt and for all those who love him. I say this not to intimidate or threaten Mr. DeWitt, but rather because it is my sincere hope that he learns from this event the importance of moderating his temper. Thank you, Your Honor.
May I proceed, Your Honor?
Yes.
Your Honor, Mr. DeWitt and I have reviewed all the reports. They are accurate. I believe the recommendation is appropriate. He's glad to see that the prosecutor's deferred has been recommended. He's asking Your Honor to follow that. Just a background, Mr. DeWitt is 59, soon to be 60 years old, never been in trouble a day of his life. He was undergoing some pretty serious health concerns at the time and just lost his temper. We've all had our bad moments. He's very remorseful for his conduct. He's ready to pay all restitution and fines this morning.
DeWitt, anything you want to tell the court before I impose sentence?
To assure the court that I'm remorseful for my actions. I apologize, and it won't happen again.
Sentence of the court, I'm going to place you on 6 months prosecutor deferred sentence. You are to pay $555 fines and court costs, $180 probation oversight fees, $868 restitution to Joshua Wade payable through the court. You can pay that all today.
Yes, sir.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete an anger management program as directed by probation. You're to have no contact with Joshua Wade directly or indirectly. There is to be no assault or threatening or intimidating behavior on your part. I'll set your review hearing that's to be held August 12th, 2026, 9 a.m. I will order 365 days in jail that is suspended. All right.
Does restitution have to be paid in any certain amount of way? I never remember that. Cash
It
only?
needs to be cash.
Okay, sounds good. You can come back and do that.
I have it.
You have cash. Sounds good, Your Honor.
I think Ms. Polero probably would have told it.
That's probably true.
She did.
Sounds good, Your Honor.
Thank you, sir.
Well, he racks up the next contestant, Great Granny. Thank you for the $2. Very much appreciate it.
Or not. Demonte Love.
Yes, I'm here on
Oh,
Zoom.
he's in Zoom.
And so is the attorney. I'm probably.
Good morning, Your Honor. Shauna Bassi on behalf of Jamonte Love.
Thank you. Mr. Love, state your name.
Demonte Love.
All right. State and time set for sentencing. Counsel, you may proceed.
Good morning, Your Honor. We've had a chance to look over the pre-sentence investigation report, and there's no corrections to make on that report. But Your Honor, we are asking, Mr. Love is he's a full-time coach. He works full-time with Ford. He's very busy with his children in sports, and he also has a landscaping business that he owns. The sober link has been kind of difficult for him to manage with his schedule, his timing, the timings. He's wondering if he could maybe submit to random ETG testing in lieu of that. Also, for the probation sentence, Ms. Pilara did point out that this sentence or this charge is not it's not a serious misdemeanor, but she believed that there's reasonable grounds to depart from it. I'm asking the court if they could consider reducing it maybe to 12 months probation.
Your Honor,
Again,
Patricia
Ms.
Clare on behalf of probation, I would ask the court to follow the recommendation as put forth. The underlying charge did involve having an occupant less than 16 in the vehicle.
Yes.
I do recognize that he did plead to the operate while intoxicated. However, probation feels that the recommendation is appropriate.
Mr. Love, anything you want to tell the court before I impose sentence?
One thing I would like to say is about me being a 39-year-old, I have never been in trouble. I'm an active member in the community for over 20 years. I've been a football coach. I'm actually a head football coach. I have my own business. I worked for Ford Motor Company for almost 20 years. And I get that that I made a mistake. I take full accountability, and it will never happen again. And it was just a bad mistake. And right now, I'm just trying to get this over with, but I apologize for everything I've done.
The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. Particularly the alcohol screening and assessment identifies the benefit of outpatient treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It is therefore the sentence of the court. I am going to place you on probation for a period of 18 months. You are to pay $855 fines and cost, $100 prosecution recovery costs, $100 police agency recovery costs, and $540 probation oversight fees. When can that be paid?
looking, I can have everything paid by Saturday, March 14th, if that's possible.
Pay everything by March 16th, 2026. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete outpatient treatment, including all recommended aftercare with status reports to probation. You are to attend 1A meeting per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation. Counsel, I am going to continue the sober link unless he would like to do 4 days in jail. I'll give him that option if that's what he wants to do. Take your
We've
pick.
actually discussed that, Your Honor, and I believe that he would rather do that instead of having to worry about messing up again with the sober link. He's just.
So he wants to do the 4 days in jail?
Mr. Love?
Yes, but only if it's possible, if you could grant it to next weekend.
Well, I'm going to set the time. If you're going to do the 4 days in jail, I set the time. You don't get to run the show.
Because he's set to work next weekend, Your Honor, and he doesn't want to get in trouble at work.
This weekend.
Or this weekend. Because Ford Motor Company has a strict policy with her. But he can do it next weekend.
Yes, I'll take
And
it.
if I order it this weekend, what's he going to do?
I mean, I will have to do what you said. I'll just have to try to figure something out with work, but I will probably get disciplined at work for missing. So I'm kind of in a hard situation where with work or with you, but the sober link, another 45 days on it. I just don't want to jeopardize myself with missing or being late taking a test.
Your Honor, probation wouldn't be opposed to him going on a scram tether, then he wouldn't have to worry about missing any testing.
But that's more
Does he
money.
want to do that, counsel?
That's more money that I would have to come out of pocket by keeping that on my as a tether.
Sir, none of this is going to be pleasant. I don't think it's designed to be pleasant. You're going to have to make hard choices.
I understand that. I'll just do the 4 days.
Washtenaw County Jail. He's to report to the Washtenaw County Jail tomorrow morning, 8 a.m. What day? 12. It's February 12th, 2026, 8 a.m. I'll order 93 days in jail. Credit for the time that he served. The balance is suspended. Thank you.
Thank you, Your Honor.
Okie dokie, friends, we will keep an eye on Judge Simpson's court as we tend to do here at TCF, but let's head to Florida. Wade Mercer's first appearances.
A third-degree felony. The second charge is possession of acetaminophen hydrocodone by tartrate, which is also a third-degree felony. And then the third one's a possession of drug paraphernalia, which is a misdemeanor charge. Ms. LeBee, I believe you're entitled to a bond as far as I know. Let me see if the attorneys have any additional information before I address that bond status. Mr. McDaniel, anything?
Mr. McNally, we just request you be subject to random UAs.
Thank you both. Ms. LeBee, I'm going to set the normal bond I would set for these charges for individuals who don't get a conditional release. And it's been quite a while since you've been in trouble, but you do have some prior drug charges. So your bond's going to be $5,000 each on the two felonies. The paraphernalia is it's a packaging paraphernalia. It's not like it's a separate item like a pipe or anything like that. So what I normally do with that is $1,000 bond. So your total bond, Ms. LeBee, is $11,000 cash or surety. Ma'am, you do have a condition of random urinalysis, so be aware of that. A judge can order you to be drug tested, ma'am, as long as the case is still pending and you're on bond. And if you have something in your system you don't have a valid prescription for, that could violate your bond. Ms. LeBee, you'll get to use the phone in a few minutes, ma'am, to try to post the bond. Do you have any questions?
No, sir.
Have a good day, ma'am.
Yep.
If we can give her notice, please, for March 3rd. Thank you for reminding me. March 3rd at 8:30 will be her court date in felony court. And then we have Philip Wilson. Mr. Wilson, good morning. You're here because you've been accused of one count of attaching a tag not assigned to motor vehicle. Mr. Wilson, there is probable cause for that charge, and I'm going to appoint the public defender's office to represent you. Please listen to Mr. McDaniel, sir.
Your Honor, I swear to Mr. Wilson, we're going to include no contest. The charges listed. You understand he'll pay a $400 fine within 60 days, or he'll serve 10 days in the county jail. He has waived his right to a jury trial and call witnesses.
Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
So, Mr. Wilson, did you hear that agreement?
Yes, sir.
Mr. Wilson, do you have any questions about that agreement?
No, sir.
And is that the plea you would like to enter?
Yes, sir.
Mr. Wilson, I'm going to accept your plea of no contest to the charge of attaching a tag not assigned or withhold adjudication of guilt. Sentence you to 10 days in jail, but you will never serve that 10 days as long as you pay the court costs and fines that are set by state and county law at the amount of $400. You have 60 days to pay those, Mr. Wilson. That means a due date of April 13th. Mr. Wilson, if you get it paid by the 13th, the case is over and you do not come back to court. I always put a court date, a follow-up court date on the notice, and here's why. If something comes up and you can't get it paid by the 13th, you've got to be back in court the very next day, which is the 14th of April at 8:30 a.m. And the reason for that is to ask for an extension. So if you get it paid, you don't come to court. The case is over. But if you need an extension, you come on the 14th, explain the circumstances to me. We'll look at how much you were able to get paid, and I'll make a decision on granting or denying an extension. But if you get it paid again, you do not come back to court. The officer did not turn any citations in with the ticket. So if there are other citations, such as driving while license suspended unknowingly, which he mentions, but there's no citation for it. If there are any other citations turned in, I intend to dismiss those because of the plea that you've entered in this case in the criminal charge. You'll get to use the phone in a few minutes, sir, and then you're going to be released this morning. Do you have any questions?
No, sir.
Wish you the best, sir. So do you still have to have the citation in this pled? So we all notify the sheriff's department? Okay. Mr. McDaniel, that's it on the first appearance list. You ready to move over to the jail docket, sir?
Yes, Your Honor.
We have William Dennis. Mr. Dennis, good morning. You have friends or family in the courtroom, sir. You're here because you've been accused of one count of obstruction of justice, and this is an arraignment, Dawn, or pretrial? I can't ever tell.
It's an arraignment.
So I'm going to appoint the public defender's officer to represent you, Mr. Dennis. You do have friends or family in the courtroom. Listen to Mr. McDaniel. We'll see where we stand in your case, sir.
Your Honor, we're going to enter plead not guilty. Ask to set this in the April 8th pretrial docket, and I'll request discovery, and we'll go from there we get back in April.
April 8th, Mr. Mitchell.
No objection to that, Your Honor.
Mr. Dennis, do you have any questions?
No, sir. Just was wondering about the bond that I'd set for before it's still in play.
Yeah, so you're not in jail on this charge at all. My understanding is you posted bond on this case.
Yes,
So
sir.
there's a bond set in the other cases. As right now, that's still the same unless Judge Garcia modifies it. But we're going to schedule you for April 8th. Let me see if your family has any questions. Any questions? All right, April 8th in the misdemeanor case. Wish you the best, sir.
Thank you.
Yes, sir. Have a good day. And the 8th will be at 9 a.m., ladies. You're welcome. Kevin Kondracki. Mr. Kondracki, good morning. You're here in case 26-25 CT, charged with one count of driving under the influence greater than 0.15. Mr. Kondracki, I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel, your attorney.
Your Honor, we're going to plead of no contest to the charges listed, $1,078 in fines. He can work those off doing public works. He'll be placed on probation, part of probation, complete CREMO, drug rehab. There'll be stipulation less than 0.15 blood alcohol content. He has waived his right to a jury trial and call witnesses, and that'll resolve this case today.
And Mr. Mitchell, is that agreeable with the state?
It is, Your Honor. I did just want to point out when I sent the docket out, there was a typo error. I thought it was a 6-month jail sentence with it being served in Chrome, I look back at your first appearance offer and it said 6 months jail or inpatient drug treatment. So we can treat it as a probation sentence with the condition he complete CROM.
And Mr. Kondracki, did you hear that agreement, sir?
I did.
Do you have any questions about that agreement?
I do not.
Is that the plea that you would like to enter?
It is.
Mr. Kondracki, I'm going to accept your plea of no contest to the charge of driving under the influence of alcohol or other substance with a 0.15 or greater blood or breath alcohol level. I'm going to adjudicate you guilty.
We would stipulate, given the facts of the case, he was caught driving a tractor around under the influence. I guess given the circumstances of that fact pattern, we would stipulate to a less than 0.15.
Okay. So you're actually pleading to less than 0.15 for first appearance purposes, even though it's a 0.183 and a 0.190. So you'll be adjudicated guilty of that offense, less than 0.15, and I sentence you to 11 months and 29 days probation with the standard conditions of probation plus the following special conditions. Mr. Kondracki, you'll pay court costs and fines of $1,078, and you'll be required to successfully complete the inpatient program at CROM. Sir, as long as you complete that program, that will fully satisfy the sentence. Because it's probation, you'll complete the inpatient and the outpatient portion of the program. I think the inpatient portion, last time I was updated, was about 9 months long. But when you finish that program, you'll check in with the probation office, and the 1,078 will likely be worked off at CROM because you'll get credit for community service that you do there at the program, and that'll probably satisfy your court costs and fines, hopefully. Ms. Colbert, are you involved in this case? Do we know when he's going to be taken over there or how, Mr. McDaniel, Ms. Colbert?
I mean, they said they should have a bed available today, so hopefully they do. I mean, everything as soon as the bed is available, and I will be contacting Fred now.
I don't know if you heard that. Ms. Colbert is in the courtroom. She said that she thinks they're going to have a bed available today. She's about to contact them and make sure. Mr. Goodson, anything?
So, Officer Campbell, I guess you can bring him up this morning so I can instruct him, and then he'll go back to the facility and report to CROM upon a bed being available. So I'm confused a little bit. Mr. McDaniel said inpatient, and you're saying inpatient and an outpatient. So is he completing both, or what is that? What do we?
Because it's probation, he's got to complete the program.
Okay.
So they'll decide what that means. But I think they have an outpatient part that is part of the program before they give them the certificate of completion. Sure. Yeah, I want him to be able to hear you, Ms. Colbert. Mr. Kondracki, you're going to make sure that we're all on the same page.
We're forcing you to talk.
Yes, sir.
Sorry, I'm a little under the weather. So yeah, the residential portion is 9 months, and then there's they call it aftercare portion that, I mean, really it's until you get blessed out, until they feel like you are ready to enter society, and I mean, I know you have a home and I know you have all those things, but whatever you need to do to be able to move back into society successfully, that's when you'll complete the program. So it could be at 9 months, it could be at 12 months, it could be at 15 months, you know what I mean? So it's not a set, but I know it's 1129 probation.
Yeah,
so within that 1129, probably.
So let's say you get to the 11 months and 29 days probation and they still haven't released you. As long as you're still in good standing, your probation is going to be terminated.
Right.
We
Yes,
can't
sir.
supervise you longer than 11 months and 29 days on a first degree misdemeanor.
Yes,
So,
sir.
Mr. Kondracki, knowing all of that, is that still the plea you would like to enter?
Yes. Yes, sir.
I just want to make sure for clarification purposes, and I know we started doing the probation, but I think they get confused when they think because we terminate people early at 6 months, he is not going to be eligible for early termination based on what is put on the record today, correct?
The only way he'd be eligible for early termination is if he completed the inpatient portion and he was in the outpatient portion, then I would consider it then. But I'm not saying I would do it, but you got to definitely complete the inpatient portion, which was 9 months long. Any questions, Mr. Kondracki?
No, sir.
All right, sir. Anything else, Ms. Colbert?
That's it.
Wish you the best, sir.
Thank
I
you.
think I got everything on there. Next case we have is Cornelius Watson. Mr. Watson, good morning, sir. You're here in case
Good morning,
25-5. Good morning. You're here
How
in
you doing,
533. I'm good. You're charged with one count of trespass. I'm going to appoint the public defender's officer to represent you, Mr. Watson. Listen to Mr. McDaniel, and then we'll see if you have any questions in just a minute, sir.
Your Honor, I spoke to Mr. Watson. He's going to plead of no she's going to plead of no contest to the charges listed. You understand he'll be placed in the jail for 6 months, $370 fine. He has 53 days jail credit. This is at the Handy Mart. Not, you obviously we know Mr. Watson has some mental issues and whatnot. And, he's alleged walking through the parking lot as he's cutting across through there going into town. But we're still going to just go ahead and plead no contest to it.
Mr. Mitchell's out agreeable with the state.
It is, Your Honor.
Mr. Watson, did you hear that agreement, sir?
Yes, sir. Mr. Mayor.
Mr. Watson, do you have any questions about that agreement?
No, sir.
And sir, is that the plea that you would like to enter?
So that's the same thing we was talking about. Yes, Mr. Mayor.
All right, so I'm going to accept your plea of no contest to the charge of
Yes, sir.
trespass. First degree misdemeanor. I'm going to withhold adjudication of guilt. Actually, based on this history, the agreement said judge guilty, but Mr. Watson sentenced you to 6 months in jail, 53 days credit. That means you've already served almost 2 months of it. So you've got
Yes,
about
sir.
4 months, left, but you certainly may do less than that with the trustee program. Hopefully you will. 370 court costs and fines are being imposed. Mr. Watson, you don't have to pay them. You'll get a chance to work them off at the jail. Is what
Okay.
if you get in the trustee program, you won't know anything when you get out if you get in that program and stay in it. Mr.
Yes,
Watson,
sir.
do you have any questions?
No, sir. No, sir.
All right, sir. Wish you the best. We have Willie Frank Hill. Mr. Hill, good morning.
Good morning.
Mr. Hill, good morning. You're here in case 24-693 CT. This is a violation of probation.
Yeah.
Mr. Hill, you're accused of violating the terms of your probation in that case. I've already appointed the public defender's office to represent you, I believe. So listen to Mr. McDaniel, your attorney, please.
Your Honor, Mr. Hill is going to admit that he violated his probation. You understand he's going to be sentenced to 30 days in the county jail. He'll have 19 days jail credit, and that'll resolve this case today.
30 days jail, 19 days credit. Any remaining court costs and fines?
None.
Everything was paid. Mr. Mitchell's that agreeable with the state?
It is, Your Honor.
Thank you. Mr. Hill, did you hear that agreement?
Yes, sir.
And do you have any questions about the agreement?
No, sir.
Ma'am, are you here on this case? You want him to know that you're here? What's your relationship so I can tell him? If I say friend, he's probably got more than one friend. Girlfriend. He may have more than one girlfriend. We're going to go with him. Don't, okay? Mr. Hill, your only girlfriend, remember that. Your only girlfriend is present. I just want you to know that she's here supporting you. So, Mr. Hill, I'm going to accept your admission that you violated the terms of your probation, revoke that supervision, sentence you to 30 days in jail, but you have 19 days credit. There are no remaining court costs and fines. Mr. Hill, that means you have 11 days at most. The reason I say at most is you may get some gain time under Florida law. That's between you and the jail. Can't promise you that. Just telling you that might happen. So, ma'am, he'll be out in 11 days or less. He could be 9 or 10, depending on how it all works out. Let me see if your girlfriend has any questions. Ma'am, do you have any questions? No. Mr. Hill, do you have any questions, sir?
No.
Wish you the best, sir. Thank you for coming, ma'am. Mr. McDaniel, it's everything I had on my docket for the jail arraignment and the first appearance. Is anything else from the public defender's office?
All right, as he wraps up his day, let's move to Texas. Judge Stevens.
But I'm looking at two cases. 23 CR 2000 and 23 CR 2001. But he didn't show up on the document on 2000.
Yeah, that's weird, Judge.
So he's charged with deadly conduct, discharging a firearm, a third-degree felony in 2000. That bond was $25,000. It's been revoked. It is now $50,000 plus GPS. 23 CR 2001, Cameron Smith, who was failed to appear. Hold it down. Thank you. Was indicted on the second-degree felony of aggravated assault with a deadly weapon. That is also a $25,000 bond. He has failed to appear. It is revoked. It is doubled to $50,000 as well as the preceding indictment. So now has a total of $100,000 in bonds plus a GPS device must be on him at all times.
I have the GPS, but I know we're hearing about that.
No, he didn't pay for his GPS
Oh,
device.
then that's
And it's
the
been revoked
problem. Okay.
from the bondsman.
I know there's-
The bond was taken back.
I know there's an issue.
Now, what was, with what?
I know there's an issue with GPS, the reason why I haven't here.
With what, the what?
GPS.
How do you spell that?
J-E-E, I'm not sure.
Exactly like it sounds. Yeah, that makes.
Give me a hard time, did you?
Decorum White.
Mr. White, right here, Your Honor. We would like to set this for trial. We have filled out our plea rejection.
Yeah, let me just go, just to make sure.
Sure.
That the record shows, since we're looking at 20 years in prison.
Yes.
25 CR 1158 is called the State of Texas versus Jacorin White. That is you, correct? And you were here with Mr. West, you were attorney and the state's attorney. You were indicted back in August of last year for the second degree felony assault on a peace officer. If convicted, that carries with it no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed as well. Let me see if I can read this. Just a second. It is tiny, super tiny. It's like I'm doing an eye test at the eye doctor here. It says the defendant stepped out of his vehicle. This all was at 1:30 in the morning when everything was supposed to be closed. And stepped out of the vehicle. They proceeded to arrest him, and then the defendant struck the officer in his face. And while he was attempting to investigate the case of why these people were there at 1:30 in the morning and not leaving a public area where the owner of the business, the property manager, arrived and advised the defendant and some other person he was with to leave, and they refused to do it at 1:30. So starts. So that's what that's all about. And okay, let's put that to file. There is no deal on that. Okay. All right. All right.
Lay down some framework. I have.
Well, this is actually Nelson.
Yes, sir. I have a motion filed. That's going to compensate. We have a plea in place.
Yeah.
But whenever it gets icy, I just want to make sure that she knows that everything. We'll get over that. Good to take. That's about.
We're talking, we had an evaluation done.
We have.
Long ago, but if the question becomes, what's going on? You know.
Alrighty, I'll keep an eye on that court, but let's go back to Judge Middleton. He's going to do a parole violation hearing from the looks of it.
This morning, pleased to see you look like that. We have two probation violation matters set for 9:30. Tina Lynn Kaufman, she's here in the courtroom. Also present is Miss Natalie Nicole Welch. This is file 251418 FY. Miss Welch was placed on probation for a charge of use of a controlled substance, which was everything you could think of. I put her in jail and I tried to get her into some treatment, some of which didn't go very well. We had tried an earlier attempt. The defendant was back in jail. She got a hold of some substance while in the jail, which was very troubling for a couple of different reasons. And so Daniel filed this probation violation petition. Let me refer to it.
And correction, it was Suboxone, not heroin.
He alleged that you were placed on probation in October of 25 for 24 months, and you used a controlled substance, heroin, which turned out to be Suboxone, in the jail on January 3rd and January 7th. I got an email this morning from Daniel. Let's see if Angelique got it.
I do. I have the.
You have the same email?
I know I have the probation violation petition as well as the status report.
Well, here is an update.
Okay.
I'll read the email. I'll forward it to you.
Thank you.
I went with the how could we do worse in treatment than we are doing with her jail option. We were struggling on what to do with her. After much work, Miss Franks, who's Lauren Franks, our pivotal liaison at the jail, after much work, Miss Franks and I finally got Natalie into the Guiding Light inpatient in Grand Rapids. Normally, they don't accept people with pending criminal issues. However, after several conversations and with the help of Ms. Franks, they decided to accept her into the program. Her case manager, Heather Hayes, and I spoke and thought that having this over her head would be a good motivator. I spoke to her and explained her options. Pleading guilty, perhaps we can put the sentencing out enough to have her complete the program, or not guilty, which we would put her on a probation. My hope is after speaking with Natalie, she will plead and we would defer the sentence. The caseworker was made aware that this is Ms. Welch's very last chance and her only option is jail if she should fail again. Natalie, Daniel and I have been discussing your case on and off through December and early January. I won't go into the details, but I understand that they got some Suboxone into the women's cells at the jail. And that you used some and acknowledged it. We had really wanted treatment rather than incarceration. And Daniel, from your email today, the defendant is currently in an inpatient residential treatment facility.
Yes, Guiding Light in Grand Rapids.
How long have you been there, Miss Welch?
I got here January 30th. I got accepted on February 4th.
Did your mom bring you some clothes?
Yes, my mom and my sister brought me up here, and they provided me with clothing and stuff.
All right, what Daniel recommended in that email is if you admit to this violation of using the Suboxone, I would simply continue your probation and set this sentencing out to give you time to complete the Guiding Light program in Grand Rapids. You look good, and I've seen you where you didn't look good. And so you've got quite a bit of clean time under your belt. If you plead not guilty to this, I guess Daniel is proposing we have a hearing and simply revoke your probation, which I don't really want to do. I'd like to see you come out the other end of this. Ms. Welch, are you willing to admit that during that period in January when you were on probation, you did use a controlled substance in violation of the terms of your probation?
Yes, Your Honor.
Anybody threaten you to get you to do that?
No, Your Honor.
Or promise you anything?
No, Your Honor.
Do you understand that you do have a right to have a hearing on this matter? We could get an attorney and actually take testimony where it had to be shown beyond probable cause that you violated your probation. I was very pleased when I saw Daniel's email this morning because frankly, I'd kind of been dreading this. Apparently you've been in a program for several weeks and I didn't know it. All right. Other than that, did anyone threaten you to get you to plead to this? I think I asked you that or promise you anything.
No, Your Honor.
All right. Did somebody smuggle some Suboxone into the women's cells?
Yes, Your Honor. That's how
And
I
on
got.
2 occasions in January, did you use it?
Yes, Your Honor.
And then you acknowledged it, you owned it. I think you admitted that you had used it. Is that correct?
Yes, Your Honor.
Tell me about Guiding Light, the program you're in.
Well, it's a very structured program. We do classes and we go to AA or NA meetings every day, at least once a day or twice a day. We go to CrossFit and we go to the 8th gym and we go to the YMCA and we do workouts for about an hour, 4 times a week. The meetings, we usually have one in the afternoon and then we'll have one around like 6 o'clock at night. And the house has 7 of us girls and we're all working on ourselves. It's a really good program. The girls here are really supportive, like we're a good community here. And I now have a sponsor. I just got a sponsor yesterday and I'm gonna be working the 12 steps with my sponsor. And the life coaches here are wonderful. In the classes that we do, like last week was self-awareness and then this week is self-compassion. So like we basically just work on our recovery here for the next 4 months. And then I plan on going to sober living after my 4 months out here in Grand Rapids. They have a sober living house for it's called the Achieve. If you complete this program, we do chores and stuff here and at home. So like we gotta wake up at 5 a.m. and we're usually working until like I would say 10 o'clock at night I go to bed. but like it's really structured here and it's a really good program.
Well, I think we won the lotto by getting you into this program. There's only 7 beds, and great credit to Lauren, Frank, and Daniel for getting you in there. So with her admission, and Ms. Campfield is also here, but I think she would agree with us, this is a good course. So she was placed on probation for 24 months in October. Daniel, at this point, we'd simply continue the probation.
Correct, Your Honor. And as she said, it was a 4 or at least 4 months before she get in the sober living. I would ask that we at least set sentencing out at least that long to give her the opportunity to make it to the next process.
So when you
All right,
guys meet, I'm sorry.
At some point, Natalie, I'm going to get off your back. I'm either going to discharge you from probation, which I would like to, or pull the pin. And right now you're doing way better than you were. You bombed out of the earlier program, but this one sounds like a good fit.
She definitely looks healthier than I've ever seen her look.
Yes, she does. I was a little bit surprised when I saw her. She looks very good. So I'm glad, Natalie, that you're taking this seriously. And how old are you? Are you 21 yet?
Yeah, I'm 21. I turned 22 in June.
All right. Well, today is February. She's been there a month. She got 1, 2, 3, 4. Let's set this for sentence for June 30th.
Oh, a day after my birthday.
Well, I can't do it on the 29th because that's a
my
Sunday.
birthday.
All right, we'll set it out for June 30th at 10:30.
Okay, and
I don't expect they'll be, yes.
so for sentencing, so will I be sentenced to jail or what does my
No, you'll
sentencing
probably
look
be
for me?
sentenced to nothing. I'm not going to put you in jail after having you in this program and doing sober living. We're just setting it out to keep this hanging over your head as an incentive to stay plugged into your treatment program.
In other words, if
not
you're successful, you won't go to jail. If you're not, you go to jail, Natalie, and you're doing great.
I'm gonna be successful.
All right, that's what I hope.
I was gonna say I don't plan on coming back to St. Joseph County, so like I was worried about my sentencing.
That might be a good thing for you,
there's
Natalie.
a
There's a lot of opportunity in Grand Rapids. And a lot of bad influences who shall remain nameless. We're down here in your B22. All right, you keep doing what you're doing and we'll address this further. No, I don't plan on putting you in jail if you're going to be successful in this program. I want you to be. Maybe this is a life-altering thing that could change the rest of your life for the good. All right, we'll address this again on June 30th at 10:30. Stay in contact with your PO so we know where you are. We also need to have a release. And probation is continued. All right, Natalie, this was a good thing. I think things are going well. I'm very hopeful for you. Mr. Truckee isn't here. He's been your lawyer since you were young, and I will share this with him that you're doing as good as we've seen you. So good luck to you, Miss Welch.
All right, thank you.
And I'll talk to you next month on the phone.
All right. Oh, what day should I call?
I just call the first week of March.
Okay.
We'll be fine.
All right, thank
Okay.
you, Daniel.
Thank you.
Thank
We have a consult with Barker's too, correct, Your Honor?
What's that?
We have a consult with Barker, don't we?
We do. Jared Barker isn't here. That's set for 9:30. Is he here? He's out in the hall, apparently. Bring them both in. but we're gonna deal with Tina Kaufman next. Ms. Kaufman, would you come up and have?
As Miss Kaufman approaches, just an FYI, the sounds that you're hearing in the background, they're doing construction at that courthouse. So you're hearing like saws and stuff, just so you know what's going on.
All right, here's another case without a good, clear answer. Ms. Kaufman is farther down the road than Ms. Welch. She's got a lot more baggage and history, but you're Tina Lynn Kaufman?
Yes.
This is file number 241968 SD. You're charged with operating while intoxicated. It was reduced from an operating while intoxicated with a high blood alcohol to that. To do a little history lesson here, you got arrested on May 26th of 2024 on Sproul Road for operating with a high blood alcohol level. Then you got arrested again in August of 2024 for operating with a high blood alcohol level in Colon Township on Burr Oak Road and Custer Road. The August case was dismissed outright, and you pled to the, the May case was dismissed, and you pled to the August case. You were placed on probation in January of 2025 for 24 months. Your probation officer is Autumn Kiefer. She filed a probation violation petition that you got arrested in, I'm not sure what the date of that offense is. We'll find out. You were convicted of operating with a high blood alcohol level, drinking, driving in LaGrange County after you had been placed on this probation. So this is set for a probation violation arraignment today. So that is the allegation, that after you were placed on probation on our drunk driving charge, you got a new drunk driving charge and a conviction in LaGrange County. And that is the number one condition of probation, not violate any law of any unit of government. The date of the offense,
June 18th of 2025.
June 18 of 25, after you were placed on probation. You got serious health issues. You're continuing to struggle, and you're on allegedly a probation in LaGrange County. Also present is Angelique Camfield from the prosecuting attorney's office, Kiefer, who was your original probation officer and who was going to be your new probation officer, Priscilla Walton. Ms. Kiefer, what's the status here?
So Ms. Kaufman, as your Honor has stated, she was arrested back in June of 2025 for driving under the influence in LaGrange County. She did have a blood result down there of a 0.27. She had been in Bowen Center treatment. However, she, as your Honor can see today, she does have some serious medical issues that have been rearing their head for the last couple months. She has been in and out of the hospital. She did plead guilty in LaGrange County. She was sentenced in the beginning of January. She was sentenced to a 1-year probation. However, in LaGrange County, they will not begin that supervised probation until other probations are completed. So they are awaiting a phone call from our office this morning to let them know what occurs today. They are aware that she's on probation here and that she has violated that order. She did serve a couple days up front down in LaGrange County from that sentence in January. She does have 5 days deferred here. I feel that Ms. Kaufman obviously has an alcohol addiction. She should be serving some of the deferred time because that's what she was told in the beginning of the sentence, is that if she did violate this probation, those deferred time, that's what they'd be used for.
However, her state today and her medical condition currently, I am not so sure that the jail is going to want to have her in their jail for 5 days. I understand and I appreciate Ms. Kaufman coming in. She's always been upfront and honest with me every time that she's reported. She was attending online 12-step meetings because of the lack of her driver's license and her medical history, so she was doing that. She had been seeing Amanda down at the Bowen Center, so that has been continuing. When she's not hospitalized for the medical issue, she is trying to follow up on all of those issues. So I would ask today, I understand this is an arraignment, but I would ask that Ms. Kaufman be revoked from this probation. I would like her to do at least 2 days in jail to push through the fact that she did violate this probation and she failed the order of the court, and then she can be released down to LaGrange County to complete their probation. Thank you.
All right, Ms. Kaufman, that's your probation officer's recommendation. We're in a strange circumstance that you can't start your LaGrange probation until you get off this probation. And you live in LaGrange County and you've been doing your treatment in LaGrange County. And each of your blood alcohol level in all three of these was very high. It was all up in the 220s or something. But you got some serious health problems. Autumn mentioned that our jail may not even accept you in light of your heart and respiratory issues. It's apparent to us that you got an oxygen tank with you. You're presently on prescribed oxygen, 24 hours?
Yes.
So this is an arraignment where the judge just tells you what the charge is. You have a right to have a hearing on the charge. You have a right to have an attorney. Your original attorney was Mr. Felt. You retained him, but we could also hire a lawyer for you. We could appoint one to assist you in the probation violation hearing. Your probation officer originally recommended 5 days. Now she's recommending 2. I don't think our sheriff will take you, even if I ordered a jail sentence. But the question here is, do you wish to simply admit this violation, or do you wish to have a hearing on it, in which case I could appoint an attorney and set it for a hearing? Frankly, it won't be very hard to prove it. You pled guilty. One of the problems, you were placed on probation here in January. You got arrested in June. So this thing has been hanging over your head since June. We didn't actually do the probation violation until you were convicted in January. So, and between June and January, you got plugged back into the Bowen Center. Is that correct?
Yes.
Tell me about that.
Normally I meet with her 2 times a month. I meet with her today also. And a couple other meetings I had to cancel because I was hospitalized.
You were just in till New Year's Eve to January 5th or 6th?
No, the last time was the 31st through the 3rd.
31st of February or January? All right. You've given yourself more of a sentence than I could. What I propose to do is simply revoke your probation, let you go to Indiana and deal with your new probation and your new treatment. You got a supreme gift. They just outright dismissed one of these drunk driving charges. And Mr. Felt was astute enough to know how bad your alcohol struggles were. But he negotiated that deal where one case was just disappeared. We tried the probation, then you got a new arrest a few months after that. In the meantime, your health has deteriorated. When did you have your last drink?
I completed treatment in August. I don't know if you'd like to see this.
Sure. So you have anything since then or since you got out?
Nope.
I was in summer of 25. All right. Are you willing, based on what I told you, to acknowledge that you pled guilty to a drinking driving charge that occurred in June of 2025 in the state of Indiana, which is a violation of your probation?
Yes.
This smells like smoke. Are you still smoking?
No.
When did you last smoke?
A couple months ago.
I'm not sure I believe that, but you're not charged with a smoking violation. But as you know, it just adds to your decline. All right. I'll note that the defendant admits to, I'm going to keep that. Can I keep that one? Do you need?
Yes.
All right. All right, you're willing to waive your right to have a hearing based on your probation violation, based on what I told you. Is that correct?
Yes.
All right, I'm going to revoke your probation. I'm going to waive all existing fine and cost. This way you can start your probation in LaGrange. You deserve a jail sentence. You deserve a significant one. But you have done some work since you got arrested in Indiana. You've been back plugged into treatment. And you're going to be on a new probation. And it's going to be very difficult for you to be in jail, oxygen and other medications. And the sheriff probably won't even take you. So I'm discharging you from probation. I want you to go with Ms. Kiefer. That'll take care of anything else that needs to be taken care of. Shows an unsuccessful discharge.
Successful, Your Honor?
Yes, unsuccessful.
All right, one feel-good event for the most part, and one maybe not as much. Let's go back to Judge Stevens' new contestant.
We now call two cases involving Ashley Diane Nelson in cause numbers 24 CR 1985 and 24 CR 1986. And you are Ashley Nelson. You are present with your attorney and the state's attorney. Mr. Jeffries, does the defendant waive a formal reading of the indictments and the arraignments in each of these cases? And can we proceed in a summary fashion?
Yes, Your Honor.
And it's my understanding that Ms. Nelson will be entering a plea of guilty to this third degree felony of obstruction or retaliation in 24 CR 1985. And as part of the agreement, the other case in 24 CR 1986, a third degree felony of obstruction or retaliation, that case will be dismissed. Is that our understanding? Correct?
Yes, sir.
Is that's what you understanding as well, Ms. Nelson?
Yes.
Okay. First of all, earlier, there was a question that arose on the defendants as to the defendant's competency. And the court ordered Dr. Ed Grappon, licensed psychiatrist here in in Jefferson County to evaluate the defendant. He did evaluate the defendant, and there is a product of his evaluation that is reflected in this 4-page report dated November 3rd, 2025. And have the parties had an opportunity to review it?
Yes, Your Honor.
And I've marked this as court's exhibit number 1 for today in this plea hearing. Any objection to its admission, defense,
None from
or state? It will be made a part of the record. And in summary, it states that Ms. Nelson is competent to proceed to a resolution of her legal issues. At this time, she is a lady who understands her current legal charge and has adequate understandings of the legal proceedings. And additionally, she does possess the ability to communicate with her attorney with a reasonable degree of rational understanding for the preparation of this case. And all of that is made part of this as court's exhibit number 1, and it will be kept sealed, except for purposes of any review as necessary legally, and not publicly. All right. All right, Ms. Nelson, in summary, this indictment in 1985 states the person who had reported the occurrence of a crime. Do you understand what all this states? You have to speak out.
Yes, sir.
Yes, ma'am. Thank you very much. This is a 3rd-degree felony, which means if convicted, you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range in this matter?
Yes, sir.
There's only one silence that now works, and it finds its way around the room. Defendant's got to sign this judicial admission at the bottom, waiving rights of appeal in a minute. An agreement has been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which means you would not be found guilty so long as you followed the terms and conditions of probation, which can be up to 5 years in length. You do well, it gets shortened to 1/3. So 1/3 of 5 years is what? 1 2/3. I'm doing the math for you.
Well, and this one, Your Honor, is the 3rd degree. I believe it was just recommended as the 5 years, but because she has done 489 days in jail as already part of this. So I guess that's what Mr. Jeffers was asking the court for the 5 years.
Well, I'm going to do that.
Okay.
But
Yes, sir.
yes, sir. I mean, the probation can be shortened.
Yes, I think just deferred probation is what.
Yes, sir.
Deferred or unadjudicated probation. Yeah, we can do it. It can be up to 10 years in length.
Yes,
But
sir.
I'm gonna go with what the plan is here and 5, and then it gets shortened for good behavior. You get rewarded. Then as part of the agreement, the other case that's pending, 24 CR 1986, which is another obstruction of retaliation, 3rd-degree felony, that will be dismissed and torn up and thrown in the trash, as it were. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement in these cases, you have no right of appeal of your cases. Do you understand?
Yes.
How do you plead to this charge in 1985, 3rd-degree felony, obstruction or retaliation, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes.
I'm going to show you what's marked as State's Exhibit 1. Now I'm going to give this to you so you can sign at the bottom. Do you see State's Exhibit 1? And you're signing that at the bottom. That waives all rights of appeal if I follow this agreement. I intend to, but do you see your other signature up at the top on the top part? Did you understand the contents and discuss it with your attorney? Is everything true and correct here? State's Exhibit 1 is tendered into evidence and without objection, Mr. Jeffries, it is admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. As we stated, you were competent to do so. And Dr. Edgar Fine, licensed psychiatrist here in Jefferson County, has evaluated you and deemed you to be fit and competent to stand trial and take care of your legal proceedings. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are guilty of this offense and any lesser included offenses. And you are totally satisfied with the representation provided by your lawyer. You have also read this instrument and understand the indictment fully. All of this, it states, is true, so help you God. States Exhibit 1 is made a part of the record for all purposes. Any objection? No. If nothing further, I will find as follows that Ms. Nilsson, you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. And even though there's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this case, I'm not going to do so, as long as you follow those terms and conditions of probation in this deferred adjudicated probation order I am signing. You will be placed on unadjudicated probation for 5 years. You do well, it will be shortened. There will be special terms and conditions of probation, and you, among other things, will be placed on a mental health caseload. And that helps you if you have any issues understanding the probation and what decisions you might make. You follow what the suggestions are and directives of the probation office. They will guide you. Their goal is to successfully bring you through this probation to complete it successfully. So at the end, if it's just a year and 2/3, I will dismiss this case as well as I'm dismissing the other one right now. So this is a win-win for you. So, but it's your part. You got to run through the tape. We can't do it for you. You've got to complete the requirements. Are you going to do it well?
Yes, sir.
I know you will. All right, and I have faith in you. Anything else?
Judge, there will be also, there was a misdemeanor trespass that was all part of the same thing. That will be dismissed as well in misdemeanor.
All right. You understand? There's some other case that's going to be dismissed, and I'm going to dismiss this cause number 1986. And that is done.
Okay.
Thank you, Jan.
Thanks. Yeah. See you. Thank you.
All right, let's head back up to Michigan, spend a little more time with Judge Simpson. Or not, because he decided to cut his feed, because that's just the kind of guy he is. So what are our other options here? Let's, as I sound like an airline pilot, let's today we'll be cruising at 32,000 feet. Let's go to Judge McNally.
All right, so we have a charge of super drunk. We have a charge of PBT refusal. He's going to plead responsible to that charge, PBT refusal. They're going to dismiss the super drunk. He's going to plead guilty to operating when impaired. True?
That's correct.
Is that what you want to do, sir?
Yes, sir.
If you do that, the possible penalties are up to 300 fines, 93 days jail, 300. You just had a case.
2 years ago, yeah. And this is a sobriety quota change. Or a sobriety quota fraud.
Oh, it's going to be, is that right?
Yes, there were notations on the other plate.
Okay.
And I can let you know, he does have his sheet. He is doing his sober link, and he has already had an intake and 2 sessions with a counselor at Delaware Gardens.
we went over the sobriety court checklist and he does want to,
He understands I have to immobilize his vehicle today, right?
today, we talked about that, Your Honor. Yes.
Okay, so if you plead guilty to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all of those. 4 points will be added to your traffic record. Your license would be suspended or revoked, in this case revoked. Your vehicle could be or might have to be immobilized. It will have to be immobilized. So I'm gonna have to order that immobilized. Your license will be revoked effective in the next couple of days. Do you understand that? I can't hear you.
Yes.
Did you sign, read, and understand an advice of rights form here today?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
Do you have his AA verification?
Yes, I've seen it. He had one.
That's all right. I don't.
Yeah, yes, Your Honor.
Has he been going 3 times a week?
Yes, he's got 11 or 12 at this point.
All right. So you understand everything that's going on here.
Yes.
You understand what a commitment that sobriety court is?
Yes, I do. I've read all the paperwork.
So you're going to have to come to status reviews every other week with me, either at 7:30 or 3 on Wednesdays, 7:30 in the morning or 3 o'clock in the afternoon. You're going to have to meet with probation in the off weeks. You're going to be going to AA 3 times a week, going to treatment, going to an armed program, testing 3 times a week during your bond phase at your own expense. Once you get accepted into the program, we will pay for the testing and the sober link on with our grant, so long as you test every time and you test negative every time. Do you understand that?
Yes, sir.
All right, I just want you to be aware, because there's no way you get through that program unless you're 1000% committed.
And Your Honor, one other thing I can say is that we know somebody mutually who was kind enough to talk to him that has been through a program in a different court. That's this Friday court in Lincoln Park, and he kind of gave him a heads up on what the expectations are and how the program really helped his life.
Good. All right, so you want to do this?
Yes, sir.
You understand all your rights?
Yes, sir.
You understand the possible penalties?
Yes, sir.
To the charge operating while visibly impaired, how do you plead?
Guilty.
Were you operating a motor vehicle on November 13th of 25 on Sibley near Racco in Brownstown at 8:25 p.m.?
Yes, sir.
Prior to that, did you drink alcohol? And if so, what did you drink and how much did you drink?
And a few Jack and Cokes.
All right, how many's a few?
4 or 5 maybe.
All right, and was your ability to operate the motor vehicle impaired due to the consumption of the alcohol?
Yes.
In what way? Why were you pulled over by the police?
We're speeding, swearing.
You think you were speeding and swerving?
A good possibility, yes.
And you think you were speeding and swerving at least in part because of your alcohol consumption?
Yes, sir.
Was this an intoxilizer test or was it a blood
It was
draw?
blood.
And you stipulate that it was accurate, that is a .199?
Stipulated.
Are you on probation or parole right now?
No, sir.
Were you in front of me on the other case or Judge Hessen or somebody else?
You, sir.
Anybody force you to plead guilty?
No, sir.
All right, I'm gonna accept your plea into the charge of PBT refusal, responsible or not responsible.
Responsible.
I'll accept that plea. I'm going to dismiss the super drunk charge. I'll accept the plea to impaired, accept the plea to PBT refusal. And I'll refer you for a screening and assessment. I hope. So we're going to have sobriety court on Wednesday next week, okay? So you'll have to make up your mind whatever one is easier for you to attend. So this is a sobriety court case. We're going to put it out, Heather, probably till let's see, let's go to like the week of the 18th of March.
Okay, so yeah, you have March 18th and you want to do 8:30?
Yes, that's perfect. March the 18th at 8:30. So you'll go fill out a questionnaire and you'll be interviewed. I'm ordering the mobilization of your vehicle. You're going to have to prepare that order, Heather. It's going to be for 90 days. And you have to have all that done by February the 18th, 1 week from today. So you have to have the vehicle immobilized. Probation will give you all your other bond conditions. And we'll see you back here then. I'll defer the sentencing, by the way, on the civil infraction of March the 18th as well at 8:30, okay?
Thank you.
I wish you well. I look forward to getting to know you and hope we can help you.
Yes, sir.
Good luck. Thank you.
Probation first, Judge. Thank you.
Yes,
Thank you.
and then he can get his notice. Or have a good day. Thanks. All right, Leslie Bolsujor versus Cynthia Hernandez. 2504922.
Right to the podium. Yeah, right next to her.
You all right?
Yeah,
Okay, tell me your name.
Cynthia Hernandez,
Your name?
Leslie Bolson.
All right. Do you two want to go talk about this before I start swearing people in?
No, I don't.
Just relax. Let me just read something that's attached. Wow, you did actually draft something here. I don't know who drafted this for you, Ms. Bosajor, but I could make a case that this is a security agreement. I'm gonna do this a little different. Right now, the car is titled only in Ms. Hernandez's name. Bring any documentation with you that tells me that you made the payments?
Me?
Yeah, you. Now, before we go on, I'm gonna swear everybody to a note. And I'm gonna try to do this a little different. But I want you to know you're under oath. I'm gonna ask both of you to raise your right hands, please. You solemnly swear or affirm under penalties of perjury that the testimony you will give at these proceedings will be the whole true self you got. Ms. Bosajor, Ms. Hernandez?
Do.
Let me see the proof that you have that you made the payment. She attached to her complaint documentation that does spell out that you were to pay $3,000. And there was a payment made on October the 2nd that you, by the way, initialed of $500, and again on November 5 of $500. Do you have any more documentation that indicates that you made any other payment? Let me see what you got.
That right there, then that. That's her.
Whose writing is this in?
Not right. And then on the back is what you was right.
Oh, wait a minute.
Those are my notes and then.
Ma'am. You're under oath. On the first two payments, you guys both initialed the $500 payment. And then you just added 2,000 paid on September 25th that you wrote on the back of this, right?
That was the notes I kept from the day that we put the car in my name, the day that the Secretary of State that I gave her money. That's when the title that I had went into my name. She kept notes, I kept notes. Oh, I wrote a contract.
No. I want to know if that's your story and you're sticking to it because you're under oath. This is going to be easier than I thought. Are you telling me you paid her $2,000 on September the 25th?
Yes.
How'd you pay the did she pay you 2,000 on September
No,
25th?
Your Honor, absolutely not. Didn't have the money. She had to bail herself out of jail. That's why I offered her my college.
Come up in front of my report. Show her that document. You ever see that page?
No.
I neither. Mr. Hernandez, who do you think that you are coming in here and trying to
What?
put that back? Give me that back, please. Who do you think you are coming in here with notes on the back of that document?
That is horrible.
Expecting me to buy this. And now you come in here defiantly and no, I don't want to talk. I don't care if you talk. You owe her $2,000 at minimum. Okay? How are we going to resolve this? I'm sorry?
You said I don't want to talk. I just want to be asked. If you asked me a question, I will definitely answer it.
You didn't pay. You didn't pay.
On September 25th at the Secretary of State. And here.
September 30th is when you guys executed this other document. You signed it October 2.
That was when I gave her $500 on October 2nd.
Yeah.
2 payments.
I don't want to hear it. I don't want to hear it. I don't believe a word you're telling me. I don't believe a word you're telling me. There's nothing here that would add up to you paying $2,000. So if you want to act like I can't add 2 and 3 without a calculator, just you continue doing that. You're late, Mr. Robertson.
Everything was cash, Your Honor.
I wouldn't expect you to, ma'am. You're in a courtroom. Okay? I don't want to hear another lie. You're in a courtroom. There's nothing here that adds up to you paying that $2,000 in cash. This was dated October 2 by you. This first page. Is this your signature?
Title is dated 25th of September.
Ms. Beausejour, you come up here. You come up here too. Whose signature is this?
My signature.
Okay. Why would you sign something October 2 saying that you agree to pay $500 per month beginning October 1 with the last payment due on March 1? That would be 6 payments at 500. 6 times 5 is 300. Now you come in with this cockamamie document on the back that you hand wrote and says you paid $2,000 on September 25.
That was the second document that was made up. There's copies.
Quit while you're behind. It's 82-0. There's 2 outs, 2 strikes, and nobody on. Don't lie to me another second. I'm gonna really get agitated here. I told you not to lie to me when you came in here. I told you not to lie to me the other day. I sensed that you were gonna come in here and lie to me. I kept an open mind, and here it is in black and white. There's no judge in the country that's going to be convinced that you paid $2,000 on September the 25. Ma'am, you just decided to fabricate a document here. That's all you did. Ma'am, talk to some other judge, some other place. You're going to figure out right now how you're going to pay your $2,000. You guys, though, Ms. Bozajor, I don't know what to tell you. You just can't do this and trust people. Were you guys friends? Were you friends?
I dated her brother in high school and we were Facebook friends. And she contacted me via Messenger on a social media ad. And I should have never answered the phone. I really should have. I did all kinds of stuff for her.
You're going to go figure out where you're getting it. Hang on. You're going to go figure out where you're going to get the $2,000 today. Then everybody will be happy. So sit in the back, figure out how you're coming up with $2,000 today.
I don't have $2,000.
Well, you had enough gumption to come in here and lie to me.
I'm not lying.
You're lying to me, ma'am. I see the title.
That's what?
You're lying to me. There's no way. You signed a document, the one I just showed you. It said that you were going to pay $500 payments starting October 1. And you made a payment on October the 2nd that you both initialed, saying you paid $500. Then you paid another $500 on November 5. Then it's blank. If you'd have paid on October 2 and November 5, the car would have been paid off. There's no indication her initialing anything. This is what happens when things are done in cash. Ma'am, I'm making my ruling. And I'm telling you, I don't know what I'm going to do right now going forward. You're not going to come into this courtroom and lie. Well, you're just under oath. That's perjury. Perjury. It's one of the easiest calls I've had in the last 17 years. Maybe 31 and a half. You figure out who you're going to call to come and get the money to pay this lady. Right now. And then we're going to go from there. I'm going on to another case. Now, I could make you transfer the title over to her because you violated the terms of this purported security agreement. But I don't think that's fair with her. To her. You're going to figure out how you're coming up with $2,000, but you're not going to come in here and lie to me. Jeremy, Kristen, let's have a seat, you two. Jeremy, Kristen.
All right, real quick, we're going to continue to run with Judge McNally, but just an FYI, 4th hour today will be more court. I'll talk more about that later, but more court. And Fleur-de-Lis, you're asking who Michael Groff is. Michael is, quite honestly, the backbone of what we do here. He is a panelist on Sidebar. He is a co-host of mine on In the Blind. I know that some links have been dropped for that. That's a separate show on a separate channel that we do. And he is the guest host here when I can't do this show. Michael's the best, so certainly get to know him. Anyways, let's ride some more with Judge McNally.
46 to Lowe's, correct?
Yes, Your Honor.
And is that correct, Mr. Granata?
Yes, Your Honor.
If you plead to this, possible penalties are up to 500 fines, 90 days jail, costs or all those. Do you understand that?
Yes.
You are presumed innocent. You need to wear those sunglasses. Do you have some eye issues?
I mean, this,
Is it an eye issue or you just feel like wearing some?
right in my system.
If you plead guilty, you're giving up your right to a trial. You're giving up your right to remain silent. You're giving up your right to question their witnesses at a trial. You're giving up your right to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses, and a testifier remains silent. If you remain silent, that silence would not be held against you. By pleading guilty, you're giving up all those rights and we won't have a trial. Do you understand that?
Yes.
You agree to plead guilty to this charge.
Yes.
You understand the possible penalties, and that along with it, you're going to pay $1,146 to Lowe's through the court in restitution.
Yes.
To the charge disorderly conduct. How do you plead?
Yes.
Were you at 21,000 West Road at Lowe's, May 31 of 25 in Woodhaven?
Yes.
And did you commit the offense of retail fraud by stealing property that was valued at $1,146 that was not recovered?
Yes.
What kind of property was that?
Those right.
I know, but was it toothbrushes? Was it gum? What was it? I mean, come on. I know it was Lowe's property. What kind of lawn equipment? Lawnmowers?
Lower.
What else?
Fleet house.
And you walk past the register somehow without paying for those items
Yes.
with the intent to deprive them of that property? Are you on probation or parole?
Yes.
For what? You understand by pleading, were you on probation or parole on May 31 of 25?
Yes.
And that's for CCW?
Yes.
You understand by pleading guilty, this would be deemed a violation of that probation or parole, and that parole or probation could be revoked as the case may be, and you could be incarcerated. You still wish to plead guilty?
Yes.
Anybody force you to plead guilty? Please accept it. Did you guys ever get that, I'm gonna accept your plea to disorderly conduct, dismiss the retail fraud, order a pre-sentence report? Was there any indication, counsel, did I ask your appearance since we started on this? Okay. Was there any indication of alcohol or drug use or anything?
No.
I'm gonna order a pre-sentence report and a sentencing date.
Was a co-defendant, Your Honor, who does not.
I see. All right, give me a sentencing date. Heather, we're going to make sure this stays on my docket day. This is an off day. So what would that be, like March the 2nd or something?
Yeah, March 4th, Judge.
March 4th. And we'll do this at
I
8:30.
will be in court March 4th as well.
Okay, March 4th at 8:30 a.m. Okay? You're going to go down the hall, get your notice. Then you're going over to probation where you'll fill out a question. You're going to be interviewed, okay? Wish you well. Good luck.
Mr. Robertson, I'll call you tonight.
Thank you.
Your Honor, the lady from Knight's thing's back with some paperwork that they said you noticed.
Oh, where's that?
She did pay,
file?
it was found online, Judge, that she did pay, and she has the
Oh, in the
receipt
pro-
from
do you have the
Joni. in
files
her-
or do I have the files? Who has the files?
You have them, Judge.
Here you call it, right. Oh, here it is.
Here, come on up here, ma'am. Call Brownstown in here. Is this my Brownstown day?
It is.
Good. All right. I'm gonna help you. Next time you're gonna be a little bit more diligent, okay? All right. Let's do this. Call in. So just to be clear, she paid 25B 82558 in full, right? $198. Is that true, Heather?
Correct, Judge, and there should be a receipt in the paperwork there that if she
Okay.
handed it to you, or she has it.
Good morning. How are you? Your appearance? So again, she showed up. This is a show cause. She wasn't here. Failure to register rental property. The default was entered. citation was issued back in April 11, 25. She paid it last night. You have a misdemeanor here. I was telling her she had to go get a lawyer because she's not a lawyer and it's a corporation, as you know, and it's a misdemeanor.
Right, we spoke yesterday about that.
You want to just dismiss this now?
Yeah, they're still not.
Oh, they're not?
I sent to the ordinance officer the inspection report. They even scheduled the re-inspection tomorrow. Right, so we need the re-inspection to take place before they can.
Okay, good enough. Well, wait a minute. I can't do anything more then. This is what I'm gonna do. How long will it take her to do everything the township needs her to do?
Hope if she passes this inspection, it'll be pretty quick.
Well, I know, but when's the inspection going to take place? Good. We're gonna reschedule this to February 18th. She's gonna need, ma'am, you're going to need to hire a lawyer. Now, if you pass inspection and you're willing to dismiss beforehand, that's fine. This is Judge Hessen's case. The civil infraction was my case. That's taken care of. So this is gonna be in front of Judge Hessen next week. You're gonna go down the hall, get your notice. If you pass inspection tomorrow, talk to Ms. Foley Carter. Maybe she'll dismiss it. Otherwise, you have to have a lawyer, okay? All right? Thank you.
Judge.
It's TCF Live on a Wednesday. Good having you all here, viewers around the world. I hope you're all having a good day. So, again, fourth hour, we're just going to do more court today. You know, we started the fourth hour a few weeks ago. It continues to be an evolution. Mrs. TCF and I are actually planning out some strategies to make it a little more regimented, but I told you going in it was going to be a little bit of an experiment. But for today, quite honestly, I haven't seen a whole ton of court cases where I would want to pontificate for hours upon, and as well, there's not a whole lot of court-related news that has my attention at the moment other than the Nancy Guthrie disappearance, but that's kind of in limbo at the moment. There's just a lot of weird going on, but not a lot of weird that's easy to discuss. So we're going to continue with court. Let's we'll stay in Michigan. Let's go to Judge Mom. Move from dad to mom.
Okay, perfect. Thank you. I'm just adding that into the ROA here, sir. Sir, your name for the record, please.
Alexander Gutierrez.
All right, thank you. Is it Gutierrez Rizzo?
Yeah.
Okay. Okay, and today is the date scheduled for the arraignment pretrial in this matter. And counsel, as to the arraignment, you're wanting to waive the formal reading?
Correct, Your Honor.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then as to the pretrial, counsel.
Judge, we did have some discussions and they were positive this time, but I'd like to take a look at the discovery and come back in for more pretrial.
The court has signed the discovery order.
Thank you, Judge.
And we can adjourn this to February 25th. Does that work for you, counsel?
Well, sir, just let me double check, please.
We'll give you the time here in the afternoon.
Pardon me, Your Honor?
It'll be in the afternoon. I'll give you the time here. Just one moment.
Okay, that's great.
Yes.
Afternoon.
145.
45, yes.
Okay, and counsel, as to bond, but just one moment. I'm told that if we need to do copies, we can do the copies in probation.
Okay.
Because their printer is on a different network.
I don't know if this one here is working.
I don't believe so. You can try it, but because everything's down, because the printer in probation is a different network.
Yeah.
I don't know. Okay, and so counsel, as to bond.
Judge, he turned himself in. He's working. Never had a case like this before. I asked the court to consider personal bond.
Sir, where do you work?
Construction, major contracting.
That's the name of the company?
Yeah.
Yes?
Yeah.
Have you ever failed to appear in court for any reason, sir?
No.
Are you currently out on bond in any other jurisdiction?
Yeah, this is the cases. Oh, no.
You're not on probation or parole anywhere? If you're in the test right now, sir, what's in your system?
Nothing else.
When's the last time you consumed any alcohol?
That day the incident happened.
Okay. The levels that are alleged are pretty high, sir. The court wants to ensure that you're not going to, that you're going to reappear in court and you're going to follow the conditions of this court. The court's going to order your cash bond to continue. By your counsel, your client did post a $500 bond.
Sorry.
No, that's okay. And the court's also going to order you not to possess or consume any alcohol or drugs unless prescribed, and you are to participate in random testing. You're going to go over to probation. We're going to receive a copy of the bond conditions, and you're also going to get set up with your random testing. Counsel, if you can also go to probation, you can then get a copy of your discovery order. Okay?
Thank you, Judge.
That's where all the copies have to remain today.
Okay.
Then we'll see you back on the 25th.
Thank you, Judge.
Thank you. Have a good day.
Have a good morning.
You're on the record in the matter of Erica Bond, 23910A.
Attorney Corey Westmoreland appearing on behalf of Ms. Bond. Ms. Bond, please for the record.
Erica Bond.
Good morning. Today is the date scheduled for the show cause hearing. Actually, it's going to be an adjourned show cause because you had agreed to pay $100 per month beginning October 16th. Did you pay those?
I paid one payment, since the court date, but I have recently lost my job and, been having some problems at home. My pipes burst in my car.
Okay, ma'am. Did you contact the court at any point to let the court know that you would like to amend your payment plan?
No, because actually I wanted to come in front of you and talk to you about maybe getting some community service, trying to work something out with you about that.
Ma'am, what's the date that you made your payment?
November, I believe.
Okay, so December, January, and now February. That's 3 months of no communication by you to request a different type of payment agreement. You know that communication is the best way to stop getting in trouble.
I know, ma'am. I know. I just have had a lot of stuff going on.
Well, ma'am, I understand. However, had you paid the fines and costs in 2023 and 24 when they were all due, then you wouldn't have this also on your list of things that going on.
And honestly, I had a question, if I could ask you a question. I've been applying for jobs like crazy. I've been getting interviews and I have been hired, but when I go to the background check, they call me and tell me that they aren't able to hire me. Is there any way I can go about getting like the things that were dismissed and I wasn't charged for off my record? So it's easier for me to find a job.
Well, you'll have to communicate with your attorney on that because there is a way that there's certain motions that can be filed on those cases, but I don't know. But that's something that your attorney would have to communicate with you on.
Okay.
Okay, ma'am. So how are you supporting yourself otherwise?
Actually, I was door dashing, but my car just broke down a couple weeks ago. So I tried to get it fixed, paid for it to get fixed, and they weren't able to fix it. So I'm like in a jam right now.
Well, ma'am,
Your Honor, is community service an option for her? You know, if I know some courts, for every hour they do, they are able to knock off $15 or $20 an hour worth of community service. I mean, not the whole thing, but at least put a dent in it.
well, here's the concern that the court has. there was a total of $1,625 due and owing when your client was sentenced June of 2023. And if I am doing the math correctly, your client didn't even make one payment. No, I'm sorry. She made a couple payments. Ellie, what does it show her last payment was, other than the $100 in November?
That's the one I see, but she had a ton.
What's that?
That's the only I see was that bridge. But before that was on.
Oh, okay. So the bond was applied. Mr. Caldwell that had posted it agreed to apply the bond. And your client did make one payment while she was on probation. Not one. Then on a probation violation, after she was sentenced, the court ordered your client to serve 20 days revoked probation. She was to report December 12th. She did not report, and the court had issued a warrant. Then April 3rd of 24, she was in custody and she served 20 days from the probation violation. And so then a year and a half later, she's in court on the show cause. She pays one payment and doesn't communicate, doesn't make any other payments or otherwise. So I'm not very inclined to grant your client any community service in lieu of fines and costs, because your client hasn't really done much by way of accountability in this matter. When's the last time you worked?
It was in September.
Ma'am, how are you supporting yourself other than DoorDash? I understand you were doing DoorDash and then your car broke, and so
I've been applying. I've gotten many interviews. I went to the interviews, got the jobs, and they've called me back after my background check. I've passed the drug test, passed all their stuff. They call me back and say the background check did not come back good. They cannot proceed with the hiring.
okay. But I also think, ma'am, that there are other matters that you have pled guilty to that weren't dismissed. So that is possible that that's affecting.
It's honestly, the job told me that it's the violent things with Peyton and my ex that is holding me back from those jobs.
Well, then, and those are matters that were dismissed?
Yes.
Then there's motions that can be filed, so you have to communicate with your attorney about that. In the meantime, ma'am,
The only reason why I asked for the volunteer work is because I'm trying to get my life together, and I've been doing good. I've been getting these jobs, but can't be hired because of my past. And I'm trying to do something. I'm really trying to do that. And I have time now. I can volunteer even at the Salvation Army or wherever you guys tell me to, anywhere. I can volunteer. I have time, right now.
yeah, but you can contact the court, and you didn't do so for 3 months.
I understand.
You could have sent an email requesting community service.
Oh, I didn't know that you could even do that. I thought that I would just have to call up here and ask for a court date.
No, could have asked for an alternate payment plan.
Oh, okay. Yeah, see, I wasn't aware of that at all.
Well,
I should have called.
or emailed. Email is a very efficient way of communicating and getting responses. We're going to adjourn this matter to March 25th and see where you're at, ma'am. Does 8:30 work, Ally?
Yes.
Ma'am, there are many places that hire individuals with matters on their criminal history. So, you should look and see where those are. I'm also going to order you to submit 30 job applications per week. And submit proof by Friday each week. Obviously not this Friday because that's in 2 days. Okay? All right, we'll see you back.
Thank you.
Have a good day.
It's episode 229 today of TCF Live. Again, great to have you all here with me. No better way to spend the day than with you guys. Louisiana Parole Board.
Our remote site is Allen Correctional Facility. I really like that background there, Warden. It looks good. I'm going to allow the staff there at Allen to introduce yourself.
Well, good morning, everybody. I am Assistant
Look
Warden
out!
Jesse Bellamy.
Thank you. And ma'am?
Jessica Manual Classifications.
Great, thank you. Today we're having a parole hearing. Would the offender please state your name and your DOC number for the record?
Gary Sherman, 500129.
And Mr. Sherman.
Yes, ma'am.
Sure. Okay. I'm going to read some identifying information from the record, and then we'll be asking you some questions. We also have some people here in support, and we also have some people here in opposition. Okay, come on. Sir, I find that you're a first-class offender, that you're currently serving a 25-year sentence for forcible rape. You have a parole eligibility date 1/7/2026. You're not eligible for good time release, but you have a full term date of 10/7/2029. Any conflict with that? Okay. I'd like to before we begin hearing from other people, I want to hear from you. I want to ask you, could you explain why you are incarcerated and why we should consider early release at this time?
First, I want to say I take full accountability of my actions. There's no excuse for what I did. And what led me to be incarcerated is I made my daughter perform oral sexual act on me while we was riding around in my car.
Okay.
That was something that should have never happened. Giving me a chance to early release. I think I rehabilitated myself and seek the proper treatment, which is risk management. It gave me the knowledge and understanding of the 27 risk factors that I had no knowledge of before I came to prison. Didn't know how to seek help. Well, let me say it like this. My pride got in the way because I didn't want to ask for help because I was scared. But now that I know it's okay to ask for help, and I understand the actions that I've heard many people, my daughter and my family, and I'm just want to say I apologize for my action.
So, would you elaborate on what you have done to prepare yourself for release?
Yes, ma'am. I got my GED. I took Thinking for a Change, which changed the way I think. And that was like one of my biggest things when I was out there before I became incarcerated. I would never think before I act. Now that I have taken this class, it had really helped me to realize every action, everything you do is a reaction. So you want to think things through before you act. And I learned how to control my anger by taking Cajun Rage and showed me that basically when you're angry and you in control of that. It's how you choose to control that anger. And the main thing I took the victim impact class, and that just really opened my eyes because it made me see from the point of view of a victim. And when I seen the things that they have to go through, the trauma, this is not just one episode, it's lifetime they have to deal with. And it just made me realize the pain that I have caused. And I took I seek the spiritual classes. I went to a year in Bible boot camp to learn about God. I know you have to change your heart. And I learned God is the way. I took many more classes like NCR to give myself a chance in society to be productive in society. And by me working at Prison Enterprise for like 8 years, it helped me with my warehouse skills to be able to be productive whenever I'm released. And I just look at life totally clear now because when I first before I came to prison, I didn't have no education, no hope. And then this experience has like, it's changed the way I look at life.
Thank you. Assistant Warden, would you like to make a statement about this offender since he's been, I think, with y'all for quite some time?
Yeah, he had done a good job on taking care of all his programs and things like that. So he had done good on that part also with his conduct. So
I think it was 2 write-ups and last one was in 2009. Is that correct?
Yes,
okay. Just want to make sure my notes were correct. At this time, we'll go ahead and hear from your aunt, Elizabeth Sherman, who would like to speak. If you'll approach the podium and then just direct your comments to the panel.
Say good morning to you. I'm the head. Also, I'm the mother. Because his mother got killed 20-some years ago. I had to be the one to step in and raise them both. My mother, she just turned to a different person. I guess you all know that his mother was killed pretty brutally. And it was hard on me because I was working as a single mother myself, trying to raise these 2 kids with my mother. And they all were good kids in school. And I couldn't make a statement about no education. But he was going to school, and I think he went all the way up to I would say 7th grade, 8th grade. And as he got older, he started acting out. And I tried to be there for him, but like I said, I was a single mother working 11 to 7. I work night, get off in the morning. I always go by my mom how make sure they get to school. If they miss the bus, I'm taking them to school. And as he got in 7th grade, I know he made a change. Like I say, I couldn't be there to really be there to hold him down. And he was acting out at home. I would get off of work and go home and to my mom and try to get him straight. He always listened to me. He never, disrespect me or nothing like that. And, he was a good child. He never hang with a bad crowd. He was a little lonely. He stayed to himself. But in my mind, I was thinking about what is going on in his mind. But he was 8 years old, so he really didn't remember too much about the death of his mother. And as he got older, he got out there in the world, how that goes, lived with his little friend. And I never know him to do no bad things. He didn't rob, he didn't do anything bad. For this to come up, it really touched me. It really broke us down. And I feel like a lot of that come from what happened with his mother. But I went on, there's no excuse for what he did, I know. What a state of mind he was in when he did it. I never know him to do any drugs. I think it was brought up that he was on drugs or had did drugs that day. I can't remember because I was in trial when it, when it happened. Like I said, he was a good child. He respected my mother and he also respected me. I never had no problem. My mom never had. But this to come up, it really did touch me. I couldn't believe it myself.
Thank you.
And
Appreciate your comments. Do you have something to say about now? Or?
okay, now I think he have learned his mistake. I heard him say that he learned his mistake. He know he done wrong. There's no excuse for what he done. And I'm not holding him. He got no excuse. But what he did was wrong. I have talked to him over and over, and he have told me, and this, I know I hurt you, and I hurt my grandma. I said, and your sister also. But they're very close. He never wore for nothing. When he in prison, we took care of him. And the prison account, all of them gave us a good report, how he studied and did right in prison while he was down all the years. And he said, once I get out, he made her a promise and also promised to him. He said, I'm gonna do right. And I'm gonna make y'all proud of me.
Well, thank you. We're going to hear now from Tina Baptiste, his sister.
So sorry.
Sorry, baby.
I'm emotional.
I was going to say, we understand that, so just relax and speak from your heart to us about what you need to say.
Absolutely. First and foremost, thank you guys for allowing my brother to have this opportunity. I wrote down a couple of dates. I do employee relations for a living, so I'm a trained not to crier. And I'm crying and I'm shaking, and that's not what I'm trained to do. So I'm gonna rely on my training and my skills. And I'm gonna go very high level and get to the point. First and foremost, 1980, so I'm gonna throw some dates out there. My brother was born in 1980. I was 6, and all I knew is I was gonna have a brother. And my mom, I was probably going to the first grade, and she said, you're gonna have a brother. It was the summer, I was out of school, and this little big hip gentleman popped up. And my mom said, this is your brother, and you gotta take care of him. And I'm like, no, I don't, because I'm the golden child, and I've always been the golden child. But there was something special about my little brother. I'm gonna fast forward through some dates. My childhood, when our mom was alive, my brother played outside, just an average Southern kind of lifestyle outside, got dirty a lot. We had friends, we had good food. And we knew one thing, our mom loved us. My mom would affectionately call him our little man, and he was our little man. I called him a boy, always happy, always running, and full of life. So that's how I remember my brother. And one thing that I will say as I stay in the 1980s for just a couple seconds more, my brother always looked up to me. And I didn't understand why, but I knew he looked up to me. Like I said, I was the golden child. I wear that very proudly, even to this day. And it's just something about the way he always appreciated me. He always told me the truth. If he was a toy that was broken, and I'm like, did you do this? Yeah, I did it. So keep that in mind. My brother always told me the truth. So as time moved forward, unfortunately, we lost our mom, 1989, February 14th. I remember it was a Tuesday. I remember the time, I was asleep, and heard all this commotion outside of my grandmother's house. And that was the day my brother and our world changed. And what I say about our world changed, because love, my mom, my grandmother, my aunt, keep in mind, I'm gonna keep talking about being the golden child, because it's gonna make sense here in a minute. I can't remember my brother, where he was that day when our mom passed away. I don't remember my brother at the funeral, but I remember my Aunt Liz. And she said to me in front of my mom's casket, "You're gonna remember this day forever. You're gonna remember everything about this day." And I can't remember my brother. But my Aunt Liz said, "You're the strong one. And I want you to remember that. You're the strong one." She repeated over and over. And I'm like, these people keep telling me I'm the strong one. But I can't remember where my brother was. And I know I was a kid, but it hurts because I cannot remember where my brother was. And I say this in this moment, and please understand when I say this, I can't remember where my brother was. I can't remember, and I hold it to my heart. But I'm gonna say it again, like Aunt Liz, like you're the strong one. And I never understood what that meant. So let's keep passing forward through the years. Then this happened, my Aunt Liz called me. I don't know where in the world I was, and I didn't know this was happening. I call this the years of the whirlwind. And my Aunt Liz, always there, always will be, and she's sitting here right now for me and my brother. I don't remember at that point the whirlwind I call.
Could you get to the point where about your brother's release? I understand
Yes,
he's going
that's what I'm
to.
gonna do now.
Okay.
So I'm gonna take you to the first time my brother was locked up, and this is where the commitment starts. When we first saw my brother in jail, he was behind the glass. That broke my heart, broke Aunt Liz's heart. And here's where I tell you, my brother made a commitment to me. I can't remember what year, but it was the first year he was locked up and he was behind the glass. And my aunt said to him, "We cannot come here. Look what you're doing to your sister behind the glass." So a couple years floated by. We went back to see him. He was not behind that glass. He said to me, "I'm never going to be behind that glass. I am doing what I'm supposed to do." He told me in those moments that there was something that happened. He told me this, what happened with him and his daughter was very hard for me to hear, but he looked me in my eye. He owned it. He owned it, and he owned it, and he owned it all throughout these years, and he never stayed behind that glass.
Is he going to be living with you when he releases?
Yes, I'm gonna get to that point. I live currently in Denver, Colorado. And when I knew my brother was coming up for parole, I did the work. I reached out a couple years ago when I knew that this was coming. There's a place in Colorado called the Center for Employment Opportunities, where I spent a lot of time volunteering, and they help provide me with some counseling and some techniques to understand what my brother is going to be facing. And then they actually have a job ready for him. For the Center of Employment Opportunities, we have a offer letter that we were able to do where he would be employed when he reaches Denver. I also have my residence, but I also have my father's house in Colorado who are willing to partner with me to make sure that my brother stays the course and help me understand the interstate compact that we have to be able to do.
Have you started that process?
Yes, yes. Now, like I said, I'll go ahead and wrap it up. I will say this as affectionately as I can. I am my brother's keeper. And I will never leave his side. And I didn't know why I was going to dive into now, because I am my brother's keeper. So that's what I'll leave you with. In terms of success, I've exceeded all expectations that anyone could have ever expected. And all I want to do is bestow that on my baby brother who I love. And I know he will never let me down because he hasn't. So I leave you with that. I have done my job. And I've been there and I am never, ever leaving his side.
Well, he's
and
lucky
there
to
will
have
never
you.
be that. Thank
He's
you
lucky to
kindly.
have you. We also have Keisha Brown, who would like to speak. No, she's changed her mind. Huh? She has chosen to speak on camera. Ms. Brown, it's your turn to make a statement.
Okay, how y'all doing today? I'm making a statement saying that David Sherman has changed. I have seen a change in him, and he does deserve a second chance. I talked to my daughter, our daughter, about how would she feel about him getting out. And she says she's fine with that. She's not scared of him and stuff like that. But I know he didn't intentionally try to hurt her. He was on drugs at the time when she came home and told me what happened. And I pursued to do the charges and stuff like that because she was scared of him. But as the years went by, when I talked to him, when he saw him, he apologized. And a person know when a person is sincerely sorry. And he was sincerely sorry to hurting our child. And he apologized to her with a sincere heart. So yes, I do think he deserves a second chance. And we both have forgiven him. So that's all I have to say, that he deserves to be out.
Very brave of you to be with us today. Thank you very much for your comments.
You're welcome.
Now we have Mr. Philip Terrell, who is the Rapides Parish District Attorney, who would like to speak.
Good morning, ladies and gentlemen. Other than taking someone's life, I can't think of anything worse than raping one's own 7-year-old daughter. Sherman confessed to making his own 7-year-old daughter perform oral sex upon him when she was just a little child. She was entrusted to his care, and that's what happened to her as a result of that. She was entrusted into his care by Ms. Brown, who just testified in favor of his release. He was charged with aggravated rape, and immediately after his arrest, he confessed that he had in fact made his 7-year-old daughter perform oral sex upon him. The jury was picked and the trial began. As soon as this is reflected in the minutes of the court. I wasn't there, of course, it's 25 years ago, more than 20 years ago, but the court minutes clearly reflect what I'm about to tell you is accurate. After the state confession was played, and the jury was made aware of his confession and heard it. His defense lawyer asked for a recess and asked the state if there would be any possibility of any plea to a lesser thing that might result in a less than an automatic life without benefit of probation or suspension sentence. The state agreed because the only witness left of any import would be the 7-year-old child. The state agreed to allow him to plead to the charge of forcible rape, and with a stipulated stipulated sentence of 25 years. And that was done so the state, he confessed to the jury that he had committed aggravated rape. But in order to prove the case, the state would have had to put the 7-year-old child on the stand. She would have to go through the trauma, relive the trauma of her father raping her again. So the decision was made to allow him to plead to forcible rape, and he got a sentence of 25 years. The minutes of the court also reflect that he was present in open court with his lawyer, Mr. Blaine Williams, who was a very competent criminal defense lawyer. Mr. Williams has since passed away, but he was an excellent lawyer, did a good job for his clients. He was fully boycotted. He signed a plea form. He made a deal for 25 years to keep himself from having to go to Angola for his life, the remainder of his life. These nice ladies testified about the progress that their nephew and brother had made, and they had really good things to say about how he done well in prison. But if you notice, his aunt didn't say anything at all about the victim, and his sister mentioned the victim in one sentence and said that he had expressed to her that he was sorry, that he had expressed to his sister that he was sorry that he did it and that it wouldn't happen again. You know, these nice ladies also, the nice aunt said that that while she had had a tough time because of her having to work and not always be there supervising. But if you'll notice, she said he never stole, he never did drugs, he didn't do any of that. Well, that sounds a little bit to me like he may well be a pedophile. And the science shows that pedophiles and rapists very seldom change. But back to the main point. The main point is, and it's admirable, and I know that he has had a very good prison record, and it is admirable. He has done well. He's taken a ton of courses to do better. But you go back to the fact that he committed this horrible crime. He made a deal with the state of Louisiana and with his victim that he would do 25 years. So simply, I could belabor that all day long, but simply put, the man made a deal to keep from going to prison for the rest of his life. And the state of Louisiana submits that he should remain in prison and do his entire sentence that he got that is a blessing to him and was a good deal that his lawyer got. I'd be happy to answer any questions that y'all have. I usually talk a lot longer, I'm sorry.
No.
I try to get to the point.
Yeah, well, you
Thank
covered
you.
everything.
We appreciate
Thank you
that.
very
Thank you.
much. Thank you for coming.
This case has been assigned to Mr. Barra. Mr. Barra, you can leave with any questions you may have.
Yeah. When you got arrested, have you bonded out since then, or you been in jail the whole time?
Well, I had bonded out, and then they picked me up when they upgraded the charge to aggravated rape.
So on this charge, how many years have you served of your 25?
21 years and like 4 months.
Right. Tell us why you think that now would be a good time to consider a release for you. What's different?
Well, I have knowledge of 21 factors, which I didn't know anything about the risk factors, understanding the help that I could have gotten to prevent this crime from ever happening. Now that I have taken this class, and I actually took the class for almost 5 years, and I also helped the other guys in here with the class. And that has really just opened my eyes to make sure I never put myself at risk ever again. And I just rehabilitated my mind to think different than I used to think. And I just feel like I strive every day to be a better person, to learn from my decisions I made. Just every day striving to be the best person I can be today. And I just feel like I did everything I could to be a changed person. And I just feel if I get the opportunity for early release, I would volunteer my time or whatever to go into the prisons, back into the prison system, to talk to the guys that you can change. it's all on you to put in the work to change. And that's all I have.
What do you think is the most valuable thing you've learned? The most important thing, valuable thing?
The most valuable thing I've learned that nobody deserves to be a victim. And you should always think about other people feeling and what you're going to put them through if you commit a crime.
All right. That's the only questions I had.
Got a question.
Yes.
Okay, this is gonna be, I know, a very uncomfortable question, but Mr. Terrell made a comment about it. When you have a sex crime,
Yes.
and it involves like your own child or somebody close to you, and they're a child, like a 7-year-old, that's a different type of sex crime. And a lot of times the recidivism rate is extremely high because it's not something somebody would normally do. They're going to put somebody their own age, if it's aggravated rape or whatever, but this is very different. So, like I said, the recidivism rate is very high when someone gets back out. Have you taken classes for this particular type of sex crime?
But the risk management, we talks about pedophiles and all that nature.
Yes.
And I now understand that something you should have never done, and that's the worst thing a person could do, and I take full accountability for that. And I can honestly say, things I know today, I would never do those things again. I would never put myself at risk, anybody at risk for that to ever happen again.
Not that I think this is an excuse, believe me, but were you using drugs or alcohol, or, you just?
At that present time, ma'am, I was using drugs, but I can't recall on that day, but I used to do drugs and I seek the proper help for that. And I went to NAAA and I learned that I was not thinking when you're on drugs, and therefore I hate drugs. Never want to be around drugs ever again.
Well, people who will do that they don't have to be on drugs. That's a mind thing going on, brain issue. Okay, well, that's what I wondered. Had you had any specific specialized classes concerning that particular type of sex crime? And you say, okay.
I believe we've heard from both sides. We've asked our questions. The panel is prepared to vote. Mr. Barrow.
This is a tough one. Let me just say that. I see that you've done a lot of good things while you've been in jail. You got a lot of support letters, even from prison staff. You're low risk on your Tiger score, your programs, which in the evaluation said too many to list, which I agree, you did a lot of programs. With the victim being in favor, kind of sways me a little bit from where I was before we started this hearing. I do understand what Mr. Terrell is saying also. So all of that being said, I'm going to vote to grant you parole to an approved residence. You're not going to get out without an approved residence, and that you're going to complete all the sex offender requirements and stay involved in sex offender treatment the whole time of parole. In other words, even if they say you don't need it anymore, I'm saying you need to stay in treatment the whole time. If you get out of treatment, then we got a problem. You need to find a support group, stay in that group, stay into it. That you have a curfew of 10 p.m. to 6 a.m. with electronic monitoring. That you attend AA and NA one time per week. That you get a mental health evaluation on the outpatient. That you have no contact with any juvenile unsupervised, period. And The reason I'm granting you parole is that if we hold you until the final, we don't have any say-so over these conditions. And we're just putting you back out without any support groups and without any other oversight. So the point of the until supervision ends is the key to your release today. So don't go and assume that, oh, it's 2 years and I haven't had a problem and I'm still doing good and the doctor says I'm fine. I don't care about that. You're going to stay into some kind of support group for sex offenders and stay into treatment for the whole time. That's my vote.
Stapleton.
Based upon everything that Mr. Barra just said, and all the conditions he put on you, I think it's a better decision to do that than to wait until a full-time date and then you just get out and we don't have any of this continued monitoring to see how you do and for you to see how you're going to do. Because right now you're in a very secure situation to prevent anything from happening. So everything he said, I concur with, and I'm going to grant your parole based upon all the conditions he named.
Mr. Sherman, I will never negate the seriousness of your crime. However, I have to commend you for the tremendous work that you have done while incarcerated to prepare yourself for this day. You know, you made a comment early on, you had no education and no hope. Well, today you sit before us with education and with hope. And you have a path forward. My vote is to grant parole. We'll put you under supervision. My vote is to grant you only to the Interstate Compact to Colorado. We appreciate what you've done to prepare yourself. You've been granted today. That concludes at 10:01.
Thank you.
Denied. Approved?
So look, we've seen the board do this a couple of times now where they grant an early release because if they do so, they can keep tabs on him, as opposed to if he sees out the full term and then he's just let loose. So, you know what? I can see where it's controversial, but I get it. It kind of makes sense because here's the thing. If he's truly changed, he's going to follow all of these conditions and it's going to work. If he hasn't truly changed, they're going to find out real fast and his butt's going to be back in prison with even more time. So, I mean, is it risky? Sure. Is it any riskier than letting him see out his term and then putting him out there? It's probably less risky this way because there is supervision. And if he screws it up, he's going to get even more time and be put away for even longer. So, you know what? I get it. I really do. I don't know if there's a better way to do this here, and I kind of appreciate where the board's coming from on this one. Just my thoughts. We've got about 15 minutes left. Let's go to McNally.
On the register, it's printing out Judge Heston. Do you know, is this mine or hers, Heather?
Let me take a look, Judge. What's the date on it?
Sir, your name?
Brandon Daniels.
All right, so you're charged with driving on a suspended. I don't know if it's mine or Judge Heston's. We're figuring that out.
It
looks
it
like
is yours, Judge.
Okay, so I'm going to just change it on the register here. You have the right to a lawyer if you want one, or I'll arraign you. Let you go talk to the prosecutor, whatever you want to do.
I just want to resolve it.
Well, I know, but do you want a lawyer or you want me to explain the penalties and your rights and let you go talk to the prosecutor?
I'm all right.
You waive your right to a lawyer? Is that what you're saying?
Yes, sir.
Okay, it is alleged that you did on January 20 of 26 operate a motor vehicle with a suspended license on Inkster near King at 9:45 p.m. That is a misdemeanor punishable by up to 500 fines, 93 days jail. Costs are all those 2 points. Do you understand that?
Yes, sir.
And you understand all your rights?
I do.
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial of any kind. Do you understand that?
Yes, sir.
All right. You still wish to waive your right to a lawyer?
Yes, sir.
$500 personal bond, not guilty, please entered. You cannot leave the state without the consent of the court or violate a law. Prosecutor. must appear in court as directed. You're gonna go sit out in the hallway. The Brownstown Township Attorney will call you in, and she will talk to you, and you see if you can resolve it either way, whether it's a plea or an adjournment or dismissal, whatever, you have to come back in the courtroom. Okay? So just go right out in the hallway and they'll set you up. Thank you.
Thank you.
Erica Elizabeth Horvath. 26I-415-206. Son failed to appear. Fault judgment centered. For failure to appear, it was scheduled for 9. Is this your only one? You came in here just for one case?
Yes, Your Honor.
All right, well, you're all set. I'm going to go ahead and enter a default judgment. If you don't have any other reason to be here, have a good day. Thank you.
Thank you. You too, Your Honor.
Bye now. We might as well take a recess.
Yeah.
All right.
And as he takes a recess, not from Jefferson County, let's go from dad to mom. We'll do that.
All right. And so, and thank you for dressing appropriately for court. Just make sure you're keeping your hands out of your pockets. Today is the date scheduled for the arraignment and pretrial counsel as to the arraignment.
Yes, Your Honor, at this time, we're my client.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And then ask the pretrial counsel.
Yes, Your Honor, at this time, city attorney offered to amend the original charge to 1 count of suspicious behavior. My client would like to avail himself of that offer and enter a responsible plea.
I'll look into the industry.
All right, sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth? Are you picking him up?
No, not better.
A little bit louder, sir.
Yes.
All right. You heard the plea that was placed on the record, correct?
Yes.
As to the amended charge of disruptive behavior, how do you plead?
Guilty. Responsible.
You've gone over your advice of rights with your attorney, correct? I'm sorry?
Yeah.
And you understand all of those rights.
Yeah.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yeah.
And you understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes.
Knowing all that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And any immigration issues?
No.
The court will accept your plea as knowing and voluntary to the amended charge, dismiss the original charge per the plea agreement. And that's $250. Do you have that to pay today?
Yes.
All right. I'm gonna go out into the lobby, sir, and somebody will be with you shortly. Sir, next time, just use the facilities at the last establishment you were at. Okay?
Thank you, Judge.
All right. Have a good day.
Sure.
Thank you. This is the matter of the city of Wyandotte versus Tashari Anderson, 2516548 and B. Mr. DePloy. Yes. That's why I said, that's why I said, you're up to bat.
I'm sorry, Your Honor.
And you said yes. I thought you were just trying to finish.
It's trouble my future. In fact, it's my present. My opponent. And apologies to you, Ms. Anderson. Lawyer on behalf of, is it Tashari that Tashari Anderson.
I think I was closer on the.
Pronouncing it as well. It's true.
Yes.
I am paired with the, with respect to Raymond Anderson, she waives formal reading at stands meeting.
All right, and ma'am, your name for the record, please.
Shari Anderson.
All right, and today is the date scheduled for the arraignment pretrial in this matter, and counsel?
Yes, Your Honor. Good opportunity to review this with Mr. Anderson as well with the city attorney. My client is requesting an adjournment. The purpose of that adjournment is to correct some defects in her driving history. Specifically, there's a reviewing this. There's a financial responsibility suspension found on record that apparently shouldn't be there. Well, not the only issue, but requesting an adjournment of approximately 30 days. And given her some instruction, although it's not my responsibility, she needs to get these things sorted out. When she comes back, you'll be in a better position to resolve this case.
Okay. And ma'am, how'd you get here today?
I was wrong.
By?
Friend,
Does that friend have a name?
Sherrod.
Is Sherrod out in the parking lot?
Yes.
What kind of car is Sherrod in?
Grand Cherokee.
What's that?
He's in a Jeep Grand Cherokee.
And he's in the driver's seat?
Yes, no.
And you don't have any keys in your pockets?
No, man.
Where do you work?
I work at Courtroom in Taylor.
And how do you get back and forth to work?
Either a friend like Sherrod will take me or my supervisor should take me up and drop me off.
Okay. You want to get your license back, presumably sooner than later, correct?
Yes, ma'am.
So then stop driving.
Yes.
Okay? All right, the court will adjourn this matter to March 11th. At 8:45 a.m. And then as to bond counsel.
Yes, well, my client is very interested in getting this resolved, and I think she's on the right path. She, well, that she's in criminal history per se, other than, again, but some non-payments, financial obligations. Though she's never, you never got the court date, is that correct?
No, then.
You're not on probation or parole anymore?
No.
But you are currently employed, how long have you been at that?
It's going on 4 years.
4 years at the same, and the client, well, so she understands that she wants to get this resolved, and she walked in here alone. Of her own, court, and I want to do nothing in the mail talk. So, I don't think there's much to do. She will appear, and that's court will first hold on.
All right, have you ever failed to appear in court for any reason?
No, ma'am.
Are you out on bond in any jurisdiction?
No.
All right, the court's going to order a $5,000 personal bond. You're not to operate a motor vehicle without a license, valid license, and just have a seat. Your probation, where should they?
I'll take a probationary.
Okay, and then you'll get a copy of your bond conditions, okay?
Yes, ma'am.
All right, thank you. That's just the only working printer right now. That's why you're going to
All right, friends, that brings an end to the festivities for today, but we will be back tonight, actually. But on In the Blind, there's links for that all over the chat. Please do join us, 7 p.m. Eastern, 4 Pacific. It'll be me and Michael Groff, and we will debate 2 different topics that we have no idea what they are until we're live. And stick around for the 3rd segment, the true-false segment, because that's the best part of the show, in my opinion. It's all good, but the 3rd part's something really fun. So join us for that, and we'll be back here tomorrow on TCF, 9 a.m. Eastern, 6 Pacific, a half an hour earlier if you're a channel member. But go have yourselves a great day. Take care. God bless.